May please, Your Lordship.
Yes.
My lord, I make mention, my lord, for listing today, my lord.
Today,
Today, my lord.
motion.
Motion, my lord. The number is there, my lord. Already number.
What is the urgency?
Urgency, my lord. Petitioner is going to be retired on Wednesday, my lord. And my lord, he has a some departmental proceeding was initiated, inquiry report submitted, and main charges was exonerated. Only one mistake. They
No,
had
what
to-
is the cause of action?
But cause of that, they have to pass an order by the authority, disciplinary authority within 15 days as per rule. If 15 days is completed, but they did not pass an order. If the order has been passed, then he will be promoted. 41 junior already promoted. He has.
I don't think there is urgency at all.
My lord, because I'll take a stance, my lord.
No, there is no urgency. What is the urgency?
Urgency because of that they did not pass any order. We just stipulated by
If they do not do, can we pass an order for passing pass a direction for passing an order?
My lord, the inquiry report submitted, my lord, within already completed more than 1 month, my lord.
Doesn't
They did
matter.
not pass an order, my lord. There is a as per rule, my lord, 15 days,
Not
my
today.
lord. They have to, my lord, mandatory requirement, my lord.
Show us any case where within 15 days the report has been submitted.
My lord, report submitted.
Show us any case where 15 days is mandatorily held.
Yes, my lord. Rule says them, my lord.
No, show us any case,
My lord.
any previous case. Not today, tomorrow maybe, tomorrow.
My
Please, Your Lordship.
But we are not convinced.
tomorrow, my lord.
Yes.
Please, Your Lordship. I beg to mention for listing the matter on Thursday, Lordship.
Metaphor?
Matter for Lordship, BP is pending due to the Lordship stay order is there, Lordship. Things long, Lordship.
Matter of which year?
Matter of Lordship 23, Lordship. 2020.
Stay order is, have you filed any stay vacating application?
Lordship, it is subject to the outcome that is there, Lordship. Otherwise,
Then, where is the restriction? You go ahead.
Lordship, go ahead part is there, Lordship. Final order it should be subject to the outcome of the petition.
Subject to the outcome.
Final order should be passed in the subject to the outcome of the restriction. That is the observation is this, Lordship.
Subject, final order?
Order should be passed, Lordship, subject to the outcome of the petition.
Okay, Thursday we'll see what is the order. Who's for the other side?
Lordship, I have already informed him, Lordship, on Thursday, already.
No, please, Your Lordship. I beg to mention item number 26 and 27.
Yes.
My Lordship, this matter is argued by Senior Counsel Kiran Chaudhary. He is out of station. The matter may be fixed after 15 August, any date.
26, 27.
26 and 27.
Inform the other side. Have you informed the?
Yes, my Lordship.
It is submitted by Miss R. Begum that she is led by Sri K.N. Chaudhary, Learned Senior Counsel, and adjournment has been sought for on his behalf. Full stop. Para list after 2 weeks? List after 2 weeks. Yes.
May please,
Okay.
Your Lordship. Lordship, I'd like to mention for a listing of a matter, Your Lordship. He's a doctor, Your Lordship, and he's also
Fresh matter.
fresh matter, Lordship.
When have you
To
filed?
Your Lordship, because Lordship, he's retiring on Wednesday, Your Lordship, and he's ought to have retired at the age of 65. But if there is no interference from the court, he'll be retiring on Wednesday, Your Lordship.
Wednesday, what is the age according to you on Wednesday?
It's 65 years as per the notification.
As per you, what will be the age of your client?
He's 60 years now.
60 years.
Yes, Lord. About to be 60 years on Wednesday.
He is holding what rank?
Lordship is a director, Lordship, of the mental hospital in
No, what is the rank? Director is the post. Rank is of?
Group A, Lordship.
His director retirement is 65.
Lordship, as per the notification, it says because he is also a professor in the.
No, that is what we are asking. What
Yes.
is your cadre?
Yes, Lordship, Professor, Lordship. He's also a professor, Lordship. He's holding the post of professor also in the post.
Because director, you can be reverted back to your
Yes, yes, yes,
substantive
that's
post.
true,
What is the
Lordship. I
substantive
appreciate
post
that.
you are asking?
He is also
Okay, let us see tomorrow.
tomorrow, Lordship. Much obliged.
May it please your Lordship, with the consent of the respondent, I beg to mention item number 23 for adjournment, Lordship. Lordship, today some difficulty on the part of my senior.
Okay, okay.
Lordship, kindly fix the matter on 6/8, Lordship.
Leave it after a week. On a prayer made on behalf of Sri B.D. Das, Learned Senior Counsel for the petitioner, matter is adjourned for a week. Yes.
May please.
I beg to mention item by 18, 19, and 20, my lord.
Yes,
I'm praying for a little accommodation for 10 days, my lord.
you have filed affidavit.
No, my lord. Otherwise, the pleadings are complete, my lord. I have filed, they have, departmental also, I think they have also
Yeah, for
filed.
the petitioner in all
Petitioner,
these
madam.
cases, okay.
Petitioner.
On a prayer, inform the other side. Which
Yes.
department?
Government, my lord.
Which department?
Personal department, my lord.
Oh, on a prayer made by Sri N.J. Attorney, learned counsel for the applicant petitioner in these cases. Matter is adjourned by 10 days.
10 days, madam.
Adjourned by
Obliged.
2 weeks.
Obliged.
18, 19, 20, 2 weeks. Yes,
May I please, Your Lordship, I beg to mention item number 67 in supplementary list, Your
yes,
Lordship.
yes.
In this case, Your Lordship, leading counsel on leave, Your Lordship. The earlier occasion, Your Lordship, the respondent side filed a affidavit, Your Lordship. In this case, leading counsel instructed to me that he will
Who's,
file
who's the counsel?
as we Prasad.
Item number 67,
Supplementary list.
S.B. Prasad.
Yes, Lord.
He's not there. His name is there or not?
In leave column, Your Lordship,
Hmm?
SB Prasad.
No, he's not the counsel here. 67.
67.
67 is A. Bhattacharya, J. Sharma.
Lordship, I'll see.
Hmm?
I'll see.
65.
65.
Is it 60? Huh? Is it 65? Is it against Punjab National Bank?
Yes, Lord.
You do not know. 65?
Yes.
Yes, what is your prayer?
Here, Your Lordship, leading counsel, Your Lordship, is on leave, Your Lordship.
Okay.
Earlier occasion, the petitioner side filed the affidavit, Your Lordship. And this case, Your Lordship, leading counsel wants to file reply, Your Lordship.
Okay, have you informed the other side?
I'll inform Your Lordship.
You have to inform first, then you make a mention, not like this. First,
I'll inform Your Lordship.
we will not do.
Yeah, Lord.
This is not the first time we are telling to the members of the
Yes.
bar.
Yeah, Lord.
What is will? Just imagine you are in the other side, here is the last matter. Somebody mentions at 10:30, you wait till 4 o'clock.
Sorry, Your Lord.
That is not the practice. What will?
Sorry, Your Lord.
Again and again the same thing. Yes,
Lordship, paying for listing of a contempt matter. Lord.
Contempt matter.
19,
19 matter.
Lord, 19 matter.
What is the stage?
Hey, Lordship, they have, suppose they were supposed to file their reply, they have not filed.
Okay, Friday next.
Lord.
We have raised your lordship. Lordship, pray for listing of an item on Friday, your lordship.
Matter.
This is a pensionary matter. There was a specific direction for this
Matter of which year?
23, your lordship. But there is
Okay, Friday. Pension matters.
May I please, Your Lordship? I beg to mention item number 55 with the consent of the other side.
55, yes.
This matter relating to appointment in NRL and similar matter is pending before the division bench, which we have challenged the rule. And this
Okay.
matter come,
Have you informed the other side?
yes,
Hmm? Okay. What is your name, madam?
B Talukdar.
Miss B. Talukdar, learned counsel for the applicants slash petitioners submits that the issue is connected with a matter before the honorable division bench. See accordingly, praise for some time.
After September, this matter.
See accordingly, praise for an adjournment. Fourth para. List in the first week of September 2024.
Highly obliged.
May it be please, Your Lordship. Lordship, I beg to mention item number 8, Lordship.
Yes,
Matter may be adjourned for a week, Lordship.
matter may be.
Adjourned for a week, Lordship.
You are Miss A. Khalifa.
Yes, Lordship, on behalf of KTV, Lordship.
Okay, you are there on record. On the prayer of Miss S. A. Khalifa, learned counsel for the petitioner. Have you informed Agriculture
Yes,
Department?
Lordship.
Matter is adjourned by a week?
Yes.
1 week, item number 8. Yes,
May I please, Lord, to with the consent of the other side, I beg to mention item number 56.
56.
I'm led by my lord, senior counsel, Mr. Kane, so he's out of station, my lord. And otherwise, my lord, pleadings are complete in this case, my lord. So can it be in the month of September, my lord?
It's for orders. We have to
Yes.
see why. We'll adjourn it for today. We'll see why it's for orders. Sri A. Tiwari, learned counsel for the petitioner. Prays for some accommodation as he is led by Sri Kane Chaudhary, learned senior counsel, who is out of station. Full stop. Para. List after a week.
Deeply obliged, Lord.
Yes.
May I please, your Lordship? Lordship, I beg to mention a case for listing in admission, my lord.
Matter
2023 matter, my lord.
pertaining to,
I am appearing for respondent number 7, my lord, and the petitioner challenge the appointment of petitioner number 7 as Jal Mitra, my lord.
what is the
Yes.
urgency?
And my lord, there is stay order, my lord.
Have you filed an application for
Yes, my
vacating
lord.
stay?
Fine.
You have filed vacating
Yes.
application. What has happened to that? What happened to the IA?
There is no IA, my lord.
You said you have filed the application for vacating stay. Have you filed application for vacating stay?
Yes, my lord.
Yes, then what is the number of the IA? What happened to the IA?
I have not filed any petition for vacating the stay, my lord, but for the read petition, I am
File
paying,
an
my lord.
application for vacating, we'll have it for consideration.
My
Read
lord, pleading
petition
is also complete, my lord.
doesn't matter, it's not that urgent that we grant an out of turn listing, sorry, yes.
May I please, Lordship? Lordship, I pray for a listing of a return for 2023, Lordship.
What is the subject matter?
It's about the seniority.
Seniority, sorry, not out of turn listing, yes.
May please, your Lordship. I beg to mention for listing of a matter, 2024 matter for the matter regarding my lord promotion matter from the post of peon to the my lord LDA. My lord, what happened, my lord?
Sorry,
There's
sorry.
no interim, my lord. The department has proceeded, my lord. So I
Let them
have
proceed,
instruction-
promotion matter, there is no urgency of out of turn listing, sorry.
Well,
Yes,
There
next.
was no interim, my lord. They are proceeded to, my lord.
Lordship, matter for
Obligation.
listing in admission, Lordship. Matter related to promotion of the petitioner, Lordship.
Promotion matter, no out of turn listing, sorry.
Lordship is going to retire, Lord.
When is he going to retire?
31st of August, Lord.
Okay, Monday next, we'll see.
Must.
My
Yes.
please, I'm sorry for that, your lordship. I have taken consent over telephone, your lordship.
Which was the item?
Item 65.
Who is the council?
Ganguly, your lordship. Ganguly.
Ganguly, okay. ये तो 65 में कुछ दिया था ना? नहीं दिया. It is submit, a mention has been made on behalf of, Sri SB Prasad, Learned Counsel for the petitioner, who is out of station. Full stop. Para, as paid for list after 2 weeks.
2 weeks. In the meantime,
No. This court has also been informed that the petitioner would be filing rejoinder affidavit.
your lordship reply.
That is rejoinder affidavit, full stop. Para, list after 3 weeks to enable filing of rejoinder affidavit. Okay.
Obliged.
Yes.
May it please your lordship. Well, although this is a content matter, my lord, but there is a division bench matter which is pending. If I may just indicate, our promotions were kept in abeyance and subsequently a writ petition was filed. It was held the order keeping in abeyance as well as the cancellation order.
No, last order, we had also adjourned this matter.
It was on discount because in the honorable division bench,
Now something has happened in the,
something has happened, means thereby the authorities have issued notice to us in queue with the orders passed by this honorable court. Now they chose to comply the order in parts. While not giving us the promotions, they proceeded against us. We approached this honorable court, it was dismissed. In the appellate court, my lord, the honorable division bench took the view that do not proceed and you are at liberty to give them consequential reliefs. Now, in line with that, the contempt petition is stuck up. So neither I can go to division bench nor I can pray for issuance of notice now. In the fitness of things, my lord, let this matter come up after a month. If the matter comes in division bench, I'll intimate the matter, the difficulty we are facing.
okay. By referring to the order passed on the last occasion, that is 27/6/2024, Sri S. Bonik, Learned Counsel for the petitioners has prayed for some more time. Full stop. Para. In view of the aforesaid submission, matter is adjourned by a month.
With the content matter, your lordship, a certified copy of the order dated 19/12/2023, passed in WBC number
Where
4135.
is the order?
Is a page, starts at page 12.
Operative part.
Your lordship, your lordship, starts at page 13, the last paragraph where, as such, without expressing any opinion on the merit of the claim of the petitioner for being promoted to the post of head assistant. And this writ petition stand disposed of with a direction upon the respondent number 2 to initiate
Who
appropriate.
is the, who was the respondent number 2 there?
Your Lordship, Deputy Commissioner, Your Lordship, the representation is at page,
15.
yes, Lordship, 15. And Your Lordship, the petitioner is going to retire on 31st/7/2024.
Okay. Madam, your name?
P. Upamanyu.
Hmm?
P. Upamanyu.
Your name is not there on record?
Lordship,
Why?
Lordship, I'm appealing on behalf of my senior.
Sure, your name should be there on record. Third,
You can record.
Ms. P. Upamanyu, learned counsel appearing on instruction of Sri P.K. Roy Chaudhary, learned counsel for the petitioner, full stop, para. By this application, comma, the petitioner has complained of non-compliance of an order dated 19/12/2023, passed in WPC 4135 of 2023. By the aforesaid order, comma, the disciplinary proceeding was directed to be
Departmental proceeding, my lord.
departmental promotion by the said order, comma, direction was given to hold DPC for consideration of the case of the candidates for promotion, full stop. It is submitted that the petitioner is approaching his age of superannuation, full stop. The said order was also, it is also submitted that the said order was brought to the notice of the respondent wide representation, which however has not been paid any heed to. Para. Let notice, returnable by 4 weeks. Steps by registered post AD within 2 days. List after 4 weeks along with service report.
DPR.
May I please read? This is the contempt matter, my lord.
Yes.
Relevant portion, my lord, page number 11. Paragraph number 8, my.
Yes, please.
Next page is representation.
But this has been interfered with by the division bench. There's a stay order. Mr. Bora Government Council. Though this is a contempt matter, are you aware that the balance period
3
at
years.
3 years,
That is pending, your lordship.
and there is a stay order?
There is a stay order, 287 of 2023.
Where is
That
the
appeal
contempt?
There are, my lord, other directions, my lord, to consider in other department, my lord. Paragraph number 8.
Those are stayed.
Eight.
The directions of the Honorable Single Judge, which was based And basing upon the same, many orders were passed. Those directions are stayed by the.
In that part, my lord, there is no stay.
There is a stay.
Remaining less than 3 years, my lord, stay. But direction, my lord, paragraph number 8, my lord,
Yes.
consider in another department, my lord.
That is same thing.
Same thing. If that is state, then automatically.
You cannot go for other departments. 3 years balance period, no means no. Where is the contempt? Have you mentioned those things in the petition? We'll defer, but that is a stay order, not a final order. We'll defer this. Okay. Heard 3, F.L. Askar, learned counsel for the petitioner, who by means of this application has complained regarding non-compliance of an order dated 4/8/2023 passed in WPC so and so. By the said order, comma, a direction was given for fresh consideration of the case of the petitioner. Full stop. It, however, appears that the challenge was regarding a clause in the relevant office memorandum that consideration for appointment on compassionate ground would not be required if there is less than 3 years of service of the deceased employee was left. Office memorandum ka date did now 1/6/2015. Full stop. Para. On a specific query to the learned to Sri D. Bora, learned State Council, comma, this court, however, has been informed that the said aforesaid direction, which was passed in a number of other cases, has been stayed by the Honorable Division Bench in WA
Rate appeal number 287 of 2023.
287 of 2023. Full stop. Para. In view of the above, comma, the consideration of the present case is deferred by 2 months. If there is, full stop, if there is any development in the meantime, comma, the parties would be at liberty to mention this matter.
Obliged.
क्या बोला? एक मिनट.
Please allow.
Just a minute, sir, talk about it. 287 of 23. Yeah, 24. You have the order date? Okay.
My lord, this contempt arises out of non-compliance of the order passed in WPC 2435 of 2023.
Regarding?
My lord, lordship may come to page 10.
Yes.
Last paragraph, under the circumstances, this court is of the opinion that the petitioner has succeeded in making out a good case for interference by this court, where a writ of mandamus can be issued to the respondent. As such, the writ petition succeeds and is hereby allowed. The respondent numbers 1 and 1 to 3 are hereby directed to give effect to the select list prepared by the selection board based on participation of the petitioner, and thereafter issue order of promotion in favor of the petitioner, promoting him from MMG scale 4, promoting him to MMG scale 4 grade. The order of promotion be given effect from the date on which his juniors were promoted to MMG scale 4 grade. Therefore, above exercise be carried out and completed as expeditiously as possible, but not later than 2 weeks from the date of receipt of a certified copy of this order. Very petition stand disposed. And my lord, this order was communicated to the chairman on 23/6/2023. It's the next date.
Why are you late?
Waited in the meantime, he retired, my lord.
Oh, no, why are you late in approaching for a contempt matter?
My lord, this order was passed.
More than a year.
No, my lord. It was passed on 26/2023,
Yes.
and this contempt was filed, and the direction was given to
Within 2 weeks.
within 2 weeks from the date of receipt of the
Yes.
order, my lord. And this contempt was filed on 19/6. It's within a year, my lord. So the direction or implementation was from 2 weeks.
Okay.
So
I heard Sri H. Chakraborty, learned counsel for the writ petition, for the petitioner, who by means of this petition has complained of non-compliance of the order dated 20/6/2023 passed in so and so. So by the aforesaid direction, comma, the select list prepared by the selection board was directed to be given effect, and consequential promotion order was to be issued, which has not been done. Full stop. It is, however, submitted that the petitioner has in the meantime retired from service. Full stop. However, retired from service. Full stop. Para. Be that as it may. Let notice be issued. Huh? So steps by arrested post 4 weeks. Huh? So after 4 weeks for service report. Take steps by arrested post 15.
Mile.
May I please the lordship, my lord, this contempt has the petition has been preferred for violation of the directions contained in order dated 15/12/2023, my lord. Annexure 2, Annexure B, page 19, my lord.
Yes.
The relevant portion your lordship will find at page 20, my lord.
The last paragraph, my lord.
In view of the above, the instant writ petition is disposed of by providing that the seal cover proceeding in respect of the petitioner be opened and thereafter consequential orders be passed therein, subject, however, to the condition that there was no departmental proceeding pending against the petitioner at the relevant point of time. The exercise may be completed as expeditiously as possible, but not later than 45 days from the date of receipt of a certified copy of the order. So subsequently, my lord, by the letter dated 19/12/2023, my lord, next page 20, it has been communicated, my lord. But till then,
Heard. DP Bora. Order dated 15/12/2023, passed in WPC so and so. So the order was duly communicated. It is submitted that the order was duly communicated on 19/12/2023, in spite of which no action has been taken. What's the para? Notice, 4 weeks. Registered post AD. Registered for 4 weeks for with service report. Steps within 2 days. Submit here. Okay. Registered post.
yes, my lord. Item 5 is also,
Similar,
yes, 5/6, my lord. Almost similar order is different, my lord.
but
Order
same
dated-
department.
Same department, my lord.
And representation date?
Representation on 17/11/2023. And order dated is 8/11/2023, page 20.
A order is 8/11/2023 in WPC 7902 देख लीजिए. Or representation is
17/11/2023.
17/11/2023.
Deeply obliged.
Okay.
Maybe the law.
Yes, what is-
Second time repetition lawsuit seeking appointment on compensation ground. As per earlier order lawsuit, they have recommended the name of this petitioner along with some other person. And those other person have been appointed, but lawsuit this petitioner has not been appointed. Lawsuit will find the recommendation at page 31.
3-1.
Lawsuit.
But this recommendation says that this is in pursuance to Honorable High Court order dated so and so. No TLC recommendation available as per matter dates prior to 2015.
31, which, what is
The
your
last
name?
down below, Your Lordship. Nur Muhammad Ali.
Nur Mohammed is the petitioner.
Yes, Your Lordship.
But there is no DLC
Lordship,
recommendation.
the issue is lordship by Leonard Penna, perhaps he knows, he's suppressing. Since lordship 1996 up to 2015, In Forest Department, lordship, no DLC was required because lordship, the post holding by Forest Department are lordship state posts. So lordship, there is notification of 2007 and 8 that the lordship, regarding Forest Department appointment and compensation ground, no DLC is necessary. That is why lordship, that has been mentioned in the column. Lordship.
Then how was it done?
Yes, directly in SLC lordship. All cases,
It was
lordship.
in
Not in this, on this case.
From
other
1986 to most probably 2011 or in a lot. That's
So
it.
if
So he has been recommended by the SLC directly, lordship. Lordship will see the first order of this honorable court.
page
Lordship. At page 27 and 28, lordship, the order. They have lordship, may read the court order. Lordship. The second paragraph I am reading. Mr. Gogoi, Learned Standing Counsel, Forest Department has submitted that the case of the petitioner.
no, that consideration is perhaps not correct.
This is their own submission, lordship.
You can have any other consideration, relevant consideration, but
Mo-
since this order was passed on almost on contest,
Yes.
Sir, Lord.
but this rejection it might not be proper.
Let me take the instruction. In fact,
Okay.
most all there might be no vacancies a lot. That's why above page 31.
Okay. Heard Sri J. Kolita, Learned Counsel,
Vacancy
For
list,
the
lordship, if lordship partner
petitioner.
again petitioner.
who by means of this petition is aggrieved, has raised his grievance regarding the manner of consideration for his appointment on compassionate ground, full stop. It is submitted that in terms of an order dated 4/11/2022 passed by this court in WPC
Hmm?
2697.
2697 of 2020, comma, the matter was this court was apprised. No, wide colony, wide order, and there was a direction for consideration of the case of the petitioner as per the submissions made by the learned counsel for the parties. Full stop. It is the contention of the petitioner that the rejection is on an irrelevant ground,
Lordship.
as at that relevant point of time, comma, there was no requirement of, there was no provision for any DLC recommendation
Lord.
for in the Forest Department.
Lord.
Para, let notice be issued, returnable by 6 weeks.
Lordship,
We are,
this was second time listing, lordship. First, it was listed on February 12, lord.
what had happened there?
On that day, lordship, they were supposed to take instruction, lord.
That's the way I would get.
What instructions have you had?
No, nothing open is here.
Okay, well, 4 weeks, huh?
2 weeks,
We
lord.
are Gogoi Learned Standing Counsel Forest Department access for all,
No, Lord, respond number 1 and 3.
1 and 3. Where is Sri D. Bora, Learned State Council for 2. Extra copies within 2 days. Instruct, advice for a proper consideration. You may have relevant points to reject.
Yes, sir, Lord. Most only this
You cannot bring in irrelevant points.
thing is that might be there will be no vacancy as per clause 15. We are looking exploring for other options in the vacancy.
Vacancy, lordship, there are 400 vacancy. I have the list of ITI. I have obtained the information, lordship.
Finish the exercise, complete
Yes.
the
Obliged, sir.
exercise. Okay.
This tendency will not bar to recommend to consider my application. That observation,
That we are not saying anything. Okay. Yes, next.
obliged.
My lord, the matter pertains to revocation of suspension, my lord. Petitioner was suspended in the month of April 2023, that is 5/4/2023. And the so-called notice was served on, my lord, beyond the period of 3 months. However, the respondent would like to contend that as per Rafael Ali, since I communicated my bail order on 15/5, so it is within 3 months' time. Now, my lord, thereafter, departmental proceeding has been initiated, and my lord, pursuant to your lordship's last direction, on 7/2024, they served me a copy of the inquiry report and I've given a reply. My humble submission before this honorable.
Second show cause reply,
Yes,
reply
yes,
furnished to you by you.
Today is fixed for
On
inspection.
23rd, I have filed. Well, two small submissions. One is that, my lord, pursuant to Ajay Chaudhary, my lord, in Ajay Chaudhary, the respondents often now rely on para 22. But there was, my lord, continuous extension of the suspension order. That part they missed. In my case, not even a single review. So, my lord, in consonance with Ajay Chaudhary, the government itself has framed a guideline on 4/2/2020 that I have annexed, that as pursuant to issuance of, my lord, proposed notice, within 6 months, my lord, they have to review the suspension order. And that OM carries a penalty provision, so it's a mandatory, my lord. And as per clause 3.13.3 of the departmental manual, after the inquiry officer submits his inquiry report, the disciplinary authority is required to take a call on the inquiry report within 15 days. Now, in my case, each and every office norm issued by the department has been violated, and I have been kept on suspension.
When did you submit your reply?
Yes,
On
sir,
23rd of this month, 23/7/2024.
23/7.
that was after 3 days.
Suspension was what date?
5/4/2023.
Complete the proceeding.
Yes. That is,
What are the charges?
Charges, my lord, is a Mondal.
My lord,
Take a
Under,
bribe,
charges under?
PC Act, my lord.
Arrested.
My lord, some assistant took some money. I was never, no money was recovered from my possession. My hand was washing.
No, we are not on
Yes,
the merits. That's, we should
That
not,
is
will not cause any prejudice to you either by not accepting or accepting.
My-
Neither will cause prejudice.
my lord,
It's for the parties to take a call.
my lord.
How soon can you complete the proceeding? He has given the reply 23rd, you had said. Today is 20th?
9th.
29th.
4 weeks, my lord, because.
No, not 4 weeks. You don't need 4 weeks.
3 weeks.
Not
You will-
even a single
You
review.
will have to reply, my lord, he submitted.
I have already
You have
submitted. 25.
Then it will take 10 days, my lord.
We'll give you 15 days.
Yes, sir.
We'll fix it and we'll make an observation that if you're not able to pass final orders, then we'll consider.
Yes, sir.
Okay.
Not a single review, my lord.
Third, Sri J. Patwari, learned counsel for the petitioner. Full stop. The petitioner is aggrieved by an order of prolonged suspension dated 5/4/2023
Elected,
with a specific contention that there is no periodic review.
not even a single.
No periodic review. Full stop. It, however, transpires that the departmental proceeding was not only initiated, was initiated in the meantime and is on the verge of completion. Full stop. It is admitted by the parties that the inquiry is over, and on the report of the inquiry officer, the petitioner delinquent has submitted his response,
Hi.
which is for consideration. Full stop. Para. In view of the aforesaid development, this court is of the view that interest of justice will be served if some time is granted to the respondent authorities to pass final orders in the disciplinary proceeding. Full stop. Para. As observed above, since the response has already been submitted, let such final orders be passed within a period of 15 days from today, which, however, has to be strictly in accordance with law. Full stop. List this matter on today's 29th, 5th, on 12th.
12th.
No, on 14th.
14th
No,
August.
not 14th, 13th.
13th.
13th or 14th, whichever date.
13.
13th, Tuesday. Full stop. Para. This court, however, gives liberty to the learned counsel for the petitioner to press for revocation of the order of suspension in the event no final orders are passed by the said date.
Deeply obliged.
Obliged, my lord.
Do it on your own interest. Either you can withdraw the, drop the proceeding, or you can
Or
pass
we
whatever
put that
orders,
way.
penalty orders, but do it, complete it. Yes,
Lordship, matter regarding family pension, Lordship.
family pension.
Yes, sir.
Yes,
Petitioner is the first wife, Lordship. The husband of the petitioner had been working as a dresser in the office of the Joint Director Health Service Duty, Lordship, and he retired from service on 30/11/2015. Thereafter, pension was granted, Lordship, and the husband of the petitioner died on 6/2/2023, Lordship.
Hmm.
Thereafter, no pension, family pension has been granted.
There is the second wife also.
Yes, sir. That's one number 8. Sir.
Has the second wife done anything?
Lordship, so for my instruction, something, Lordship, and
No, you have to disclose everything. There may be a suit. There may be some other cases.
no, Lordship, there is no suit,
No case.
no case.
But she's she's also not getting anything.
No, Lord.
Nobody is getting, my lord. He says only they are trying to initiate process.
When was the death of your husband?
On 6/2/2023.
23. Okay. Mr. Chotia,
Yes, sir.
take instructions.
Instruction, my lord.
No, we'll issue a short notice. You are S alum,
Yes, sir.
Part 3 S alum, learned counsel for the petitioner who has filed this petition on the issue of release of family pension, full stop. It is contended that the petitioner is the first wife of the deceased government servant who was employed as a dresser.
Yes, sir.
Which department?
Health Department. Sir.
Health department.
Yes, under response number 4.
Or the dresser in the Health and Family Welfare Department, and had passed away on 6/2/2023. Put the para, let notice be issued. Returnable by 4 weeks. Yes, Mr. Chotia for?
I will for 1 and 7.
TC Chotia, additional senior 1 and 7. Madam for?
I am for 2, 3, and 4.
D Bora, huh? D. And D Bora 2, 3, 4.
Yes.
AG, Mr. Chakraborty. B Chakraborty, Standing Council AG Assam for 5. Treasury Officer, Chaliha, A Chaliha. Standing Council Finance Department, that's 106. Extra copies, okay? Within 2 working days, 2 days. Working monthly.
Much obliged, my lord.
Lordship, in item number 10, Lordship, I have made the party, second wife party, Lordship. That's one number 8. Sir.
8 is there.
Yes, sir.
Oh, steps for service. Where is it?
That's one number 8. Sir.
Huh? File 2? 8 dedicated. Next page of something. Steps for service of notice under upon the respondent by it be taken by registered post to AD. Steps within 2 days. Yes.
Obliged.
Next page of something. Mr. Mazumdar, what is this?
Madam, there the petitioners are tax collector cum road mower is working under the Panchayat and Rural Development. My lord, if lordship has page 36 for a moment, my lord, this was
We had passed some orders in one of the cases.
my lord, I am not aware of that.
Same matter,
Okay. Well, you should notice here. But it was contended very strenuously that there is no provision for promotion.
From the already, although the earlier notification says that it will be only done.
You will issue notice and then fix it.
Only one issue if lordship would consider, my lord. In October 2023, they had published an advertisement where they said that they would be making direct recruitments to the post. Now the RTI, if lordship has at page 94 for a moment, my lord. Out of a total of 1096 at page 94, if lordship has.
109,
page 94, my lord.
yes.
It was an RTI that we had made. Question number 2, if lordship would find. Please provide the number of GP secretaries post lying vacant till date. There are about 1096 number of post of GP secretaries lying vacant. Question number
Same,
three.
same thing, the same.
My lord, what has happened is they are not.
No, it was the same submission. We have recorded in the earlier order.
I was-
Same RTA.
I was not aware of.
In fact, same RTA. It's been circulated by a WhatsApp group.
Thank you. But I was only praying that if they make a direct recruitment to the post, if it could
We
be
have,
with the.
we have declined to pass.
With either, my lord, I'm not praying for a stay, my lord. What I'm saying is that if they just intimate, my lord, us or the honorable court before they make a direct recruitment, my lord, we can come up with a challenge then.
We'll maintain the same thing. Yes, Dr. This is N Bora. This is Armando. Mr. SLRC has not been made a party.
Look, SLRC is not a party because they have not specified that the posts are included in that
But
advertisement.
it's been done by SLRC.
No, that they have not
Should have-
specified even in the RTI that those are the posts.
You should have got the information, the India.
2024, 2024, they say that
In
we
the
have
earlier case,
proposed.
SLRC has been made party. You consider this thing.
I'll try to, I'll get an implementation.
B. Chaudhary.
Otherwise, it's only in 2024, they say that we have proposed.
We are
And
making it returnable on 21/8, same date. 21/8, list along with, last minute, list along with 3601. Make courage pencils. Give extra copies by tomorrow.
I'll do that.
I think you'll accept for all the respondents.
Oblation.
May I please, your lordship? Petitioner given that the
Okay, we'll rise for just some person. 10 minutes.
not district. Lordship.
Working as what?
Lordship, petitioner was appointed by the Commission of Excise in the year 2010, Lordship. And
No, as working as what capacity?
Assistant Inspector of Excise, Lordship.
Why salary is not paid?
Lord, you are not aware of this case. We have not been served the copy. We are not-
Let's have the
And,
copy.
no.
Hmm?
Even our name is
GSM
reflected.
also, Lordship.
GSM is not,
GSM.
is not enough. Excise department.
Even
Well,
our name is not reflected.
he was last time engaged in the commission, district commission, Bishwanath, Lordship.
Now, why haven't you served copies on the standing council? You serve copies today, we'll have it on Wednesday. Okay,
Yes,
and in the meantime, serve copies today itself.
Yes.
Take instructions.
Very well.
Okay, why salaries have not been paid? If there is some trivial issue, try to resolve it.
How much, Lord?
List this case on Wednesday for motion. In the meantime, your name?
B. Islam, Lordship.
Sri B. Islam Learned Counsel for the petitioner would serve a copy of the writ petition to Sri R. Gogoi Learned Standing Counsel Excise Department, whose name may be reflected. Whose name is to be reflected in the cause list.
Much obliged.
How much, Lord?
Give it right now and take instructions.
Very well, Lord.
Thirteen नहीं क्या है बोलेंगे?
Petitioner before your lordship is retired, my lord, Khalasi. He is not regularized, my lord, when he was retired. Therefore, my lord, pension is not paid.
Not
When
entitled.
does
Upenda, sir. Even recently, your lordship passed a judgment.
it pass many?
Yes.
Why are you advising clients to file writ petition? You
My
don't
lord,
get anything. If you are not getting any relief, why?
I have submitted, my lord, one Supreme Court judgment recently passed, my lord. Page 23, my lord.
23.
23, my lord.
That's got a Gujarat pension rule, the lordship.
Mr. See,
Well, one judgment, several
can we-
judgment passed.
can you go against the division bench? This is a single bench.
Well, recently, my lord, one judgment passed by the single bench, my lord.
Single bench, no, division bench is there. Can we say something against the division bench?
Now, only my lord,
Not
here,
permissible.
only my lord, here in this recent judgment, my lord, it is provided that my lord, if other my lord members are granted pension, then my lord, they may be also considered. Do you have this?
Without a regularization order, how
Well,
do
I
you,
will provide bring this copy. my lord.
without
Very
a
recent, my lord.
regularization order, how do you get grant pension?
No, this is provided, considering Bhupen Das, my lord, it was provided that, my lord, it has come to the notice of this honorable court that, my lord, some similarly situated candidates are given pension. Therefore, they may be also, my lord, similarly considered. That must given, my lord, nothing else.
See, in Sanjita Roy, he had given some latitude for the regularization period, but regularization was a precondition. Here in the cases which were dealt in Upendas, those were cases for regularization. There was not even a day's regularization.
Yes, my lord, this is, I was there, my lord, this is a thorough judgment, my lord, considering all aspects. my
So
lord,
why is there scope of again?
Only, my lord, this is provided that, my lord, it has come to the notice of this honorable court that some similarly situated candidates are given.
It's not a case of
So that
negative.
may be considered, my lord.
It's not a case of negative equality. If some illegality has done with others, can you seek the illegality, which is against Upendas?
Only consider, my lord, because.
Cannot.
So, my lord, I may be allowed to bring this judgment, my lord. This is a detailed judgment recently passed, my lord.
Day after tomorrow. Day after tomorrow, I'll dismiss this.
My lord, Friday, my lord.
No, not Friday. Day after tomorrow.
My lord, day after tomorrow, I have some problem. Only Friday, my
Day
lord.
after tomorrow, we'll accommodate you in the second half or whatever.
My lord.
On the prayer of 3 a.m. Borbia Learned Counsel for the petitioner. List for motion on Wednesday.
My
Para? Sri R. Gogoi, Learned Counsel for the which department?
PC department, Dr.
PHE. Standing Counsel PHE, however, contends that the matter is squarely covered by the judgment of the Honorable Division Bench in the case of State of Upendas, State of Assam versus Upendas reported in so-and-so.
My lord. Obliged.
Yes, what is this? I implement. Implement.
Implement, my lord.
You want whom to be implemented?
The director of land records, my lord.
He was not a party initially.
In the initial proceeding, he was not party, my lord. But here, my lord, the lordship may dispose of the matter also, my lord. The writ petition also.
Yes, by saying what?
My lord, here, my lord, the petitioner, my lord, he was selected for the post of Gav Pradhan.
Gav Pradhan.
Lordship. And my selection was silenced by unsuccessful candidate.
You selected as
Selection on, my lord, 3/1/2023.
as Gav Pradhan. 3.
3/1/23, my lord.
Then challenged.
And this list was, my lord, challenged by an unsuccessful candidate. And writ petition, in the writ petition, my lord, notice was issued and department, my lord, raised question of maintainability. No interim was passed.
Yes.
Because of pendency, my lord, I was not appointed. Then, my lord, on the next day, my lord, writ petition was withdrawn.
Okay.
With a liberty to file appeal.
Okay.
Because of, my lord, this, my lord, observation, I have not been appointed till this.
Which observation?
He will file appeal.
Who will file appeal? The unsuccessful candidates?
Yes, my lord. On that ground, my lord, my appointment has been stalled.
Is it the only reason?
We have, it is an inspection. As part of the record of the department, no one has filed appeal against this plot.
Then
2024.
you have to go ahead with the complete the process. Okay. You write in the writ petition, huh? Heard 3. R. Ali Learned Counsel for the petitioner. Also heard 3. Who is first?
Main petition, I am appearing for number 1.
Sri S. Datta,
Yes, sir.
Learned Standing Council Revenue Department for the respondent numbers 1, respondent number eta,
One.
and Sri D. Bora, Learned State Council for the respondent numbers 2, 3, and 4. Full stop. Para. Considering the subject matter and as agreed to by the parties, Learned Council for the parties, comma, this writ petition is taken up for disposal at the admission stage. Please have your seat. Para. A recruitment drive was undertaken for filling up the post of Gaon Budha / Gaon Pradhan in various lots wide, an advertisement dated 9/3/2022. Full stop. It is the case of the petitioner that so far as lot number 17 of Jenny JNI Musa under Bagbor Avenue Circle is concerned, comma, the petitioner had participated along with other candidates in which the petitioner claims to have been selected wide the select list, which was published on 3/1/2023, and such selection was for charge number 17. Full stop. However, comma, certain unsuccessful candidates had filed a writ petition challenging the selection process, which was registered as WPC 372 of 2023. Full stop. Due notice was issued, comma, no interim order was passed, and rather the maintainability issue of the writ petition was raised by the Learned Standing Council of the department. Full stop. The filing of the writ petition appears to be one of the reasons for not appointing the petitioner pursuant to his selection. Full stop. Para. Sri Ali, the Learned Council for the petitioner, has contended that subsequently the writ petition itself was withdrawn with a liberty to file an appeal under as provided under the rules. Full stop. The Learned Council further submits that he is not aware of any such appeal being filed, as no notice has been received by him. Full stop. He accordingly submits that those developments should not be a bar for not appointing the petitioner pursuant to a validly made selection. Full stop. Para. Sri Datta, the Learned Standing Council, Revenue Department, has submitted that as per instructions received, comma, till date, no appeal has been preferred before the appellate authority. Full stop. In this case, and in this regard, comma, he has also placed on record that a written communication dated 24/2024. Full stop. Sri Bora, the Learned State Council, submits that the matter is between the department and he would not have much role in this matter. Full stop. Para. Considering the aforesaid facts and circumstances, and also observing that there is no order from any authority or court restraining the appointment of the petitioner pursuant to his selection made in terms of the advertisement dated 3/9/2022 and the select list dated 3/1/2023, comma, the respondent authorities are directed to go ahead with the process of appointment, which however has to be done strictly in accordance with law. Full stop.
Respondent opinion 2 and 3, my lord.
2 and 3. Writ petition accordingly stands disposed of.
Deeply obliged. I may be closed, my lord.
In terms of the final order passed in the writ petition, comma, no separate orders are required to be passed in the IA, which is accordingly closed.
Deeply obliged.
Yes, what is this?
Malad, the matter pertains to non-payment of pensionary benefit, malad, area, malad. The father of the petitioner, malad, serving as a master role worker, malad. He joined on service 1/5/1985.
Can we take it for final disposal?
Yes, my lord, we have filed our affidavit, my lord. My lord can.
This is what is the issue for?
For malad, non-payment of malad pensionary benefit, malad, area pensionary benefit.
Yes.
The father of the petitioner, malad, serving as a master role worker, malad. He joined on service 1/5/1985.
Yes.
And thereafter, malad, his post was regularized, malad, kindly page 11, malad, regularizer order by 26/10/2005.
Yes.
And on that regulation order, malad, his name is shown on malad serial number 28.
Page 11.
Page 11, malad. Is the type copy, malad. And malad,
Ram Khilon
Malla.
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 That is the father of the petitioner.
Father of the petitioner.
Okay.
And thereafter, malad, after regulation, malad, kindly see page 18, my lord. The executive engineer, my lord, disputed the date of birth of the petitioner's father, my lord. Page 18.
Yes.
Page 18, my lord.
Hmm.
Therefore, my lord, he, my lord, issued a letter to the BO, my lord, Bongaigaon, for seeking verification of the school certificate, my lord.
Yes.
Thereafter, my lord, having no, my lord, quick result, my lord, comes from the BO, my lord, the father of the petitioner, my lord, filed a RTA application for the engaged counsel, my lord. Page 22. It is stated that the said verification report has not been received from the BO Bongaigaon. And also stated that the present total monthly salary of Ramkelan Malla is 5,425. Not paid the regular scale of pay.
Yes.
Well, thereafter, my lord, kindly see page 23. The verifying authority, Bijni Bandav Higher Secondary School, submitted the, my lord, verification report, my lord, wherein stated that the certificate issued in the name of the petitioner's father is verified and found correct.
Page 23, my lord.
Okay.
And that verification request communicated by the DO to the my lord executive engineer. By letter dated 14 December 2011, page 25, my lord. Page 25, forwarding report.
Yes.
After receiving of that, my lord, verification report, my lord, the no step has been taken by the respondent, my lord, and ultimately the father of the petitioner died on 28/7/2012. And this is page 26, death certificate.
He was at the time still in service.
Service, my lord. Continuing, but fixed scale of pay, my lord, has been granted due to death of birth anomaly, my lord. He is not receiving regular scale of pay, my lord. Instead, regularized.
Yes.
Thereafter, my lord, the mother of the petitioner also died, my lord, on 15 December 2015. Page 27, my lord.
Okay.
And therefore, the petitioner claimed, my lord, arrear, my lord, remaining regular scale of pay as well as, my lord, death benefit left by the father of the petitioner and subsequently family pension, my lord, left by the mother of the petitioner, my lord. That is my case, my lord. And on this regard, my lord, my two younger brother also filed affidavit, my lord, stating, my lord, we have no objection if the paid amount, my lord, in the name of the petitioner, my lord. Page 29.
You are paying for arrears of pay.
My lord.
Number one, till the lifetime of your father.
My lord.
Then the family pension, which would have been accrued to your mother till her death.
My lord.
These two relief.
My lord. As well as, my lord, the death benefit, my lord, that were dying during the course of service, my lord.
Your brothers have filed affidavit.
Affidavit, my lord. Kindly see, my lord, page 29. Annexon 9. 29, my lord. Page 29. Sobalal Malla is the, my lord, young elder son, my lord, and Bihari Malla and Keaton Malla, younger son. That two son, my lord, son in affidavit, my lord, stating that they have no objection. My lord. And respondent number, my lord, one also filed affidavit, my lord, recently, stating that, my lord, during the course of time, my lord, the respondent asked to submit the my lord, medical fitness certificate by the father, but he has not filed that certificate. Otherwise, my lord, admitted all the things, my lord, by the respondent.
Medical fitness means?
my lord, I don't know, my lord, kindly see, my lord, affidavit opposition filed by the respondent number 1, my lord.
Yes, which paragraph?
Paragraph 5. That with regard to the statement made in paragraph number 9 of the repeater, the answering deponent begs to state that after receiving the said verification report, the father of the petitioner was asked to bring fitness certificate from health officer Bongaigaon, Chanchika, but he failed to submit the same and he died on 28/7/2012. So no any step has been taken so far as drawing regular and ADR pay, etc. from this end as per record.
Why is the fitness certificate required? Mr. Fadil?
My lord, I think, my lord, it is not required, my lord, because, my lord, it is continuously serving, my lord, and regular in the year 2005, my lord. Paid the, my lord, fifth scale of 6K,
Yes,
my
that-
lord.
Okay, that is all. Okay.
My lord.
Why medical fitness is required?
My lord, medical fitness certificate always be before regularization, my lord.
That has been regularized earlier.
My lord, his name was there in the regularization list, my lord. But ultimately, my lord, the order will be passed by the, my lord, the executive engineer
No,
in the division.
that was in the year 2005.
There was an anomaly, my lord, in the date of birth, my lord.
Anomaly has been cleared.
Thereafter, my lord, we have asked for, my lord, medical fitness certificate, my
Not
lord.
be fair.
No, my lord, we never knew that.
No, from 2005 to 2011, you took time to get his age verified. It ultimately came in his favor. Then you said that you are not being able to give your medical certificate for regularization of service. What is this?
My lord, he was alive then, my lord, for a year, he was there. We asked him that
Then you leave the family high and dry. He dies, no family pension, nothing after regularization order. Not be fair. Had it been for some major reason, and 2005 the regularization order, you are not disputing that his father's name was in serial number 28. And date of regularization, yes, may have a connection with the date of birth, but the connection will be more relevant for computing the age of retirement.
Yes.
You make some preliminary exercise that you find some fault. Ultimately, that has also come in his favor. May not be fair, Mr. Dhar.
my lord, only because that he did not submit medical certificate, my lord, he did not proceed further. But that is our affidavit, my lord. I'm living a real lordship, my lord.
Okay. Heard Sri K.R. Padgiri, Learned Counsel for the petitioner. Para also heard Sri R. Dhar, the Learned Standing Counsel, Public Works Department, as well as Sri Chalia, as well full stop. Sri A. Chalia, Learned Standing Counsel, Finance Department, and Sri B. Sharma for Learned Standing Council, AGSM are also present and heard. Full stop. Para. Para. The subject matter pertains to a claim for release of arrears of pay. Oh no, subject matter pertains to certain benefits accruing to the deceased father of the petitioner, who was employed with the Public Works Department. Full stop. The claim relates to number one, arrears of pay. Number two, death benefits. Number three, family pension till the death of the mother of the petitioner. What's the parent? As per the facts projected, comma, the father of the petitioner was a master or worker in the department who was appointed in the year 1985 and had joined on 1/5/1985. Full stop. An exercise for regularization of service was undertaken in the year 2005 and in the list published on 26/10/2005, comma, the name of the father of the petitioner had figured against serial number 28. Full stop. However, comma, the father of the petitioner was not given the benefit of scale payment, and it came to be known that certain verification regarding the age of the father of the petitioner was undertaken. Full stop. Para. 3. Pargiri, the learned counsel, has drawn the attention of this court to the communication dated 25/10/2010 issued by the executive engineer, PWD, to the district elementary education officer, comma, Bongaigaon, /Chiram, for verifying the school certificate of the father of the petitioner regarding his age. Full stop. As no further development came to be noted, comma, the father of the petitioner, through his counsel, had made an RTI application, and in response to that, comma, it came to be known that till date no verification exercise was done, and the payment was also a fixed payment and not in the scale meant for regularized employees. Full stop. The verification was ultimately done by the principal of the concerned school on 13/12/2011 and was communicated by the district elementary education officer to the executive engineer, PWD, on 14/12/2011. Full stop. It has been stated that the age was verified and found to be correct. Full stop. It is submitted that while the father of the petitioner was still in service, comma, he had passed away on 28/7/2012. And at that time, he was not getting the regular scale of pay, which gave an indication that the benefit of regularization was not given to his father. Full stop. It is also submitted that on 15/12/2015, comma, the mother of the petitioner had also passed away. Full stop. The petitioner has accordingly filed this present petition for mainly for the aforesaid 3 reliefs as indicated above. Full stop. The learned counsel for the petitioner has also referred to the affidavit filed by the two brothers of the petitioner expressing no objection to no objection if the benefits are released in the name of the petitioner. Full stop. Para. Sri Ardhar, Learned Standing Counsel of the Department, has, however, submitted that the impugned action is based on certain reasons. Full stop. By drawing the attention of this court to the affidavit in opposition filed on 19/7/2024, comma, the Standing Counsel, non-standing counsel, has referred to the averments made in paragraph 5. Full stop. It is submitted that the deceased father of the petitioner was asked to bring a fitness certificate from the health officer from Bongaigaon, which was not submitted. And in the meantime, on 28/7/2012, he had passed away. Full stop. It is submitted that the requirement of a fitness certificate is there to give effect to an order of regularization, and therefore the same, and in absence of the same, comma, the effect could not be given. Full stop. Para. The learned counsel, the learned counsel, the learned standing counsel for the finance department and AG have, however, submitted that the list being between the petitioner and the department, comma, they would not have much role to play. Full stop. Para. The regularization of the father of the petitioner relates to an order dated 26/10/2005. Full stop. A bare reading of the said order would, without any ambiguity, establish that the incumbents whose names had appeared in the list were brought under the regular cadre of grade 4 master laborers with effect from 22/7/2005 in the scale of pay of rupees 2455-3670. Full stop. It is not in dispute that the name of the father of the petitioner figured in the said list against serial number 28. Full stop. The said regularization order being of the year 2005, comma, it is not known as to why about 5 years were taken to make a verification on the age of the petitioner. Full stop. In any case, comma, though such verification of age would be relevant for calculating the date of superannuation, comma, there such necessity would not arise for giving effect to the regularization order in terms of the office order dated 26/10/2005. Full stop. Be that as it may, comma, the verification exercise had also culminated in a communication dated 14/12/2007 by the District Elementary Education Officer to the Executive Engineer, whereby the particulars of the deceased father of the petitioner, more particular pertaining to his date of birth was found to be correct. Full stop. Unfortunately, within the year thereof, the father of the petitioner had passed away while still in service. Full stop. Para. The only defense which has been put forward is that by an order dated 3/1/2012, the father of the petitioner was asked to produce a fitness certificate, which he had not done. Full stop. As noted above, within a period of about 7 months from the said date, the father had passed away, father of the petitioner had passed away on 28/7/2012. Full stop. Requiring the deceased father of the petitioner to produce a fitness certificate cannot in any way be connected with the issue of giving the benefit of regularization of service, which was done by the order dated 26/10/2005. Full stop. Such certificate, such certificate may be relevant for any other purpose, but not for the purpose of giving benefit of an order passed in the year 2005. Full stop. The period from 2005 to 2012 was also on account of certain verification exercise done on the age of the father of the petitioner, which was itself initiated after about 5 years from the date of regularization, as mentioned above. Full stop. This court is of the considered opinion that the aforesaid cannot be a reason to deny the benefit of the order of regularization passed on 26/10/2005. For the father of the petitioner. Full stop. Para. The writ petition is accordingly allowed by directing the respondents in the Public Works Department to compute and pay the arrears of pay from the date of regularization, that is 26/10/2005, till the date of the death of the father of the petitioner, that is 28/7/2012, in the appropriate scale of pay, and along with the increments which he would have earned during his lifetime. Full stop. It is also directed for payment of the death benefits accruing to the father of the petitioner, as he was a regular employee from the regular employee. Full stop. The respondents are also directed to compute the family pension which would have accrued to the mother of the petitioner till her death, which is 15/12/2015. Full stop. Para. The aforesaid benefits be released and amounts be released expeditiously, and in any case within an outer limit of 2 months from the date of receipt of the certified copy of the order. Writ petition stands allowed.
But
May I please, Lordship? Kindly pass out the matter for the time being.
What is the matter, Mr. Dhar?
Lordship, I was ousted from service on the basis of the opinion rendered by the medical board regarding alcoholic
Affidavits filed.
dependent syndrome.
Affidavits filed.
Affidavit is filed. We have also filed our
Ms.
report.
Gayan will be appearing.
No, Lordship. SKD.
RKD, RKD.
RKD, sir.
Okay.
So can
when-
it be
when-
fixed on a hearing date, Lordship, and can it be taken up
On
on?
Tuesday next?
Lordship, Lordship.
Okay. Pleadings are complete and the matter can be taken up for admission hearing. What's the para? On request, list on 6th of August.
Diplo.
My lord, here I have received the instruction on behalf of respondent number one. Particular. The respondent number three, my lord.
You have received instructions.
Instruction, my lord. Sometime may be given to file it.
Who has filed affidavit, Mr. Chaudhary?
Respondent number 5.
5, you are 5.
Yeah.
5 is the state respondent.
State is
Both the center and state are involved.
Yes.
What is the matter?
regarding pension matter. I was serving in the at earlier stage in border organization of Assam Police. And after 6 years, 11 months service, I opted for service in the Sainik school, Gwalpara Sainik school.
That comes under the central government.
Yes, central government.
So you are involved,
Yes.
okay. You file your affidavit,
Yes,
matter
ma'am.
is of 22.
Yes, my
You are
lord.
playing for what? You are praying for what? What is the relief prayed for?
Yeah, my lord, the pension matter.
Pension matter, don't delay. Matter of 2022, okay.
My lord, within 2 weeks I'll file.
Heard Sri D. Chaudhary, learned counsel for the petitioner. Para. While the respondent number 5, represented by Sri D. Bora, the learned state council has filed affidavit in opposition, comma. The other respondents, represented by Ms. A. Gayan, the learned CGC, is yet to file the affidavit in opposition. Para. On the prayer of Ms. Gayan, comma, 2 weeks' time is granted to file such affidavit in opposition. Para. Since the matter pertains to pension, comma, let a date be fixed for let the next date be fixed on 2 weeks. We have said 1, 2 on 17th of May. You get
20th of
May, 17th of no 16th of August. Adequate time.
Well, 16th of, instead of 16, my lord,
14th?
22, my lord. I have to
14th,
go.
14th,
14th, yes, my lord, 14th.
14th.
Yes, 14th, yes.
April আৰু জুলাইৰ হেৰিখন
Your lordship.
খালি জুলাইত 31টা দিন আছে, এটা 30টা দিন আছে।
Wait,
Yes,
your
Mr.
lordship.
Mahanta?
Lordship, this matter pertains to pleadings are complete here.
May please your lordship, Mr. P.P. Datta appears in this matter. He is coming, lordship, kindly pass over the matter for the time being, lordship.
What is the matter about?
I may be allowed to state the facts.
What is the matter about?
Lordship, the matter is regarding EWS certificates, non-consideration of EWS certificates of the petitioners. If your lordship takes up just 2 orders, lordship, I'll just point out 2 orders.
Let him come. Let him come. Ratha would be for the APSC.
Lordship.
And madam, you for
Try to respond.
file affidavit.
Yes, sir, everything is done.
After a while.
Much obliged to.
Please, Allah. My lord, here in this case, my lord, petitioner is the second wife, claim for my lord, she is claiming for pension. Pension and baby, which is my lord given to the first wife, private respondent. But my lord, here may I pray, my lord, here my lord, already matter has been, my lord, whether second wife is entitled to maintenance on family pension or not, that has been decided by the full court, man, a full bench, my lord. And as per the full bench decision, my lord, I will have to now, my lord, file maintenance petition before the appropriate forum. So observing that, my lord, matter may be closed.
What do you say?
What the otherwise instruction received, Lord? Some instruction received.
Instruction, because already full bench has said.
If there is a full bench, we
No.
cannot say anything else.
Instruction, it will
No
further.
necessity.
Heard Sri Alhaz Uddin, learned counsel for the petitioner. Also heard Sri A. Chakraborty,
Respondent 1, 2, 3,
State
and 5.
counsel, and Miss C. T. Begum, learned counsel for the respondent number 8.
Private respondent.
Anyone else? Or private last word likhiba. A. Chaliha, standing counsel, finance department. Okay. Para. Considering the subject matter and as agreed upon by the learned counsel for the parties, comma, the writ petition is taken up for disposal at the admission stage. Please have your seat. The matter pertains to a claim for family pension. Full stop. It is submitted that the husband of the petitioner, Jamshed Ali, was serving as an sub-inspector, armed branch in the 13th Assam Police Battalion and had retired from service on 30/9/1995. Full stop. On 15/7/2009, the husband of the petitioner had passed away. Full stop. Para. It is, however, the admitted case of the petitioner that the petitioner is the second wife of the deceased government servant, and the first wife has been impleaded as the respondent number 8. Full stop. It is contended that before the death of the husband of the petitioner, he had divorced the first wife. You are disputing this?
Yes, there's no paper.
Okay, they divorced the first wife, and therefore the petitioner would be entitled to the family pension. And full stop. It is also submitted that the respondent number 8 had concealed the fact of divorce and was receiving and was claiming the family pension. Full stop. Para. Per contra, Miss so learned counsel for the respondent number 8, by referring to the, did you file affidavit? No. By referring to the affidavit in opposition. Where is the affidavit?
I will file respondent number 8 has been still.
You have not filed. No, has disputed the aspect of any divorce as full stop. It is, the learned counsel has also pointed out that in the entire writ petition, not a single document relating to such divorce has been able to be annexed. Full stop. Para. Sri Udin, the learned counsel for the petitioner, has, however, fairly placed before this court a decision passed by the Honorable Full Bench of this court on the aforesaid issue. Full stop. the said decision which has been passed in WA 160 of 2018 on 22/12/2022 has laid down that the second or other wives of a deceased government servant for whom such marriage was permissible under the personal law would approach for appropriate orders for maintenance.
Paragraph 23 of the judgment it is.
23.
Yes.
For ready reference, comma, the relevant observations made in the aforesaid judgment is extracted, are extracted here in below paragraph 23. Full stop. The learned counsel for the respondents have also submitted that in terms of the aforesaid judgment, comma, the writ petition can be disposed of. Para. In view of the above, comma, in view of the above, and in terms of the aforesaid judgment of the Honorable Full Bench, more particularly the observations made in paragraph 23, quoted above, comma, the writ petition is disposed of. Full stop. The directions of the full bench would be also applicable and followed in the present case.
May I please?
Possibly wants to get a
Extremely
one.
extremely sorry, Lord. That's regarding item number 17, the date has been fixed on 6. But on that date, Mr. Alphabet is not available. So may I pay it to be listed on 8th of August
Item number
17, Lord.
তুমি লিখিছে 8 করে দিন 11 and 8.
Yes, sir.
Highly obliged.
Mr. Bhomik, which is your case? Next case.
Yes. The matter relates to payment of pensionary and death count retirement benefits to the petitioners.
May I please, Lordship? May I please, Lordship, may I pass over the timing? Senior engaged counsel is in another group.
Who will be coming?
SP Sharma.
Wait for a while. 22 matter will like to try to finish it off.
Yes. That out of 32, 3 has already retired, Lordship.
Let him come.
But the issue pertains to promotion. The pleadings are otherwise changed, my lord. If my colleague is ready, my lord.
Affidavit is filed, the pleadings are complete. Today I am not prepared, Lordship.
Okay,
And
Tuesday
if-
next. Tuesday next. Tuesday 6th,
Can it be Thursday, Lordship?
8th,
Yes,
8th. Not tomorrow. We are talking about next Tuesday, 6th.
yes, Lordship. I
Okay,
am-
Thursday 8th. 8th is okay.
Yes.
Okay.
6 was better, my lord, but an 8 fine. If it is.
Pleadings are complete and the learned counsel submits that the matter can be taken up for disposal and then the matter can be taken up for admission hearing. Full stop para. List on 8th August.
Deep level.
Pertains to promotion from the cadre of junior engineer to assistant engineer.
With the leave of this honorable court, we have today filed our additional affidavit in opposition, Your Lordship. Nothing may I pray that this matter may be taken up from under.
Is it
the
on
account-
record?
No, Your Lordship.
You've been served.
Copy has been
Okay,
served.
next Monday, let the additional affidavit come.
And
Can it be on Tuesday, my lord? Because everything is finished, my lord. It can be taken up for.
Everything is finished or everything is complete. What is the difference between complete and finish?
Sorry,
Everything is finished will be
I'm sorry.
detrimental for your interest.
my bad.
Nothing is left. Or you are completely finished.
No. The validity of my degree.
Okay, when? Let's have it on Monday. We'll see
My
if it can.
Yes, sir.
Ms. Decca, the Learned Counsel for
Water Resource Department.
Water Resource Department has informed this court that an additional affidavit has been filed yesterday,
No, today. Your
today, which is yet to be connected, tagged with the records full stop para. List on Monday, date, huh? List on 5th, 5th of August, 5/8, along with the affidavit.
Honor.
Oh, bless.
Who is 6?
AICP not.
Okay, it's there, we'll consider.
Obliged.
May please, your lordship. Lordship, here in this matter, I have received certain instruction, lordship, but lordship, I am unable to locate that. Lordship, can this matter be taken up on
What
Friday, lordship?
matter, Mr. Decca?
My lord, matter pertains to release of the contributed money in the new pension account in the under the new defined contribution pension scheme. Base.
Okay, Friday,
Friday, lord.
on the prayer of Sri Upamanyu, Learned Standing Council, Health
Yes, lord.
and Family Welfare Department, list on Friday,
Friday,
Much
lord.
obliged.
date.
Lordship, we are filing the affidavit in opposition.
With agriculture,
Yes, sir.
31 to 42. Miss R. Bora, Learned Standing Council Agriculture Department submits that the affidavit in opposition are being filed, would be filed during the course of the day. First of para, list on Friday, along with the affidavits that may be filed
Obliged.
Friday. 2nd August.
Here, affidavit from the opposite side are required, madam. That has not been filed.
Which department, Mr. Munir?
May I please, your lordship. In this matter, lordship, instruction is awaited, lordship.
Which department?
Lordship, Guwahati High Court, lord.
What is the matter?
The appointment of peon in district and session judge.
Matter 23 matter, get the instruction.
Lordship.
Why High Court is taking so much of
No,
time to
lordship,
file affidavit?
we have entered appearance on 13/5/2024, lordship. So notice was issued last year, lordship. We have communicated the registered, lordship.
You for whom? Mr.
Lordship,
Das,
lordship.
what is your name?
NK Sharma, lordship.
Sri N.K. Sharma, Learned Counsel appearing on instruction of Sri H.K. Das, Standing Counsel Guwahati High Court, submits that instructions have been called for and are expected soon, full stop para. On his prayer, matter is adjourned by 3 weeks to enable filing of such affidavit in opposition.
There is an interim order, my lord, in 22/9.
Para, where?
On 22/9, it is that the appointment of respondent number 4, my lord, whose appointment we are seeking.
Subject to the outcome, it's already there. Not
May I pray for a date, my lord, if possible.
Let's say 3 weeks, we have said. 3 weeks.
Number one. Number one.
নাম লিখে দিব হ্যাঁ এমন নাম লিখিব হলে পি.কে. মুনির আগতে লিখিব এন্ড ডি বড় স্টেট কাউন্সিল
Much obliged.
May it please your lordship, the matter relates to the regularization of service of the petitioner, my lord. Many debts has been
Yes, irrigation department.
irrigation department, my lord.
Irrigation. Madam Niyog, Mr. Upadhyay, I think.
The petitioner had been working since 1982, my lord. After serving 43 years, The service of the petitioner has not been regularized.
From 83,
82, my lord,
82.
82. He was appointed first in various capacities. He has
In which age you were inducted in service?
His work search appointment was in the year of 1993. But
No,
prior to
initial-
1993, he had been working as various capacities.
In
as
1982, you have said.
Yes.
What was your age in 1992?
82, it is clearly mentioned in the in
Age in 1982?
Your lordships, annexure 10, page number 39, it will clearly state.
39.
Page number 39, my lord. Certified that MD Kolimuddin.
No, we are asking what was your age in 1982?
1990.
82.
82.
You said you have been working from 1982. When were you inducted in service? What age? 12 years? 13 years?
Casual, my lord.
What age?
Age, my lord, at that time.
What is your present age?
Present age, he had been superannuated in the year of 23, my lord.
That means 60 now.
My lord.
So 82, what was your age?
Almost. 18, 19.
Yes, madam. What is your case?
My lord, petitioner is appointed on 23/4/1993, my 93, my lord. So he is appointed prior to 1/4/1993. So my lord, he is a Rothas employee, my lord. So he cannot be regularized, my lord, as per Umadi's case and Upenda's, my lord.
Upendas.
Yes, my lord.
Have you filed affidavit?
No, my lord.
You file a short affidavit, take up this issue. Otherwise, you may be correct in contending. Upendas is there, Umadevi is there. Okay.
Your lordship, proposal for regularization was made in the year of
No, Mr. Counsel,
23,
before 1/4/93, there was a conscious decision to regularize, but the decision underwent a change after Umadevi. Thereafter, Upendas has come. So we'll have to go by Upendas. Let her file the affidavit.
Your lordships, annexure 10.
Miss D.S. New, Leonard Standing Counsel, Education Department, prays for and is granted 3 weeks. Submits that the matter is squarely covered by the decisions of the Honorable Supreme Court in the case of State of Karnataka versus Umadevi 3, reported in 2004, 6 SCC, page 1, and as well as the Honorable Division Bench of this court in the case of State of Assam versus Upendas, reported since. She also prays for and is granted 3 weeks' time to file affidavit in opposition. Let him have a chance, file the affidavit, at least he can rebut. Thank you.
Lordship, the hearing, Lordship, the government of Assam had initiated a scheme, Lordship, that is Jal Jeevan Mission, Lordship, with an aims and object to reach in every home.
Mr. Bhattakur, your response?
Lordship, if there's some construction going on, then Lordship, the scheme has not been handed over.
You filed the affidavit. 24 matter. At least do you have the instructions?
Instructions are awaited, Lord.
Get the instruction, file the affidavit. He should know where he is now. Okay.
Lordship, actually, one person, his Lordship approved by the Water Users Committee to be appointed as a caretaker of the PW assets. And in fact, Lordship, the present petitioner, the present respondent number A, who is directed to be appointed as a caretaker, who is not approved by the Water Users Committee. And I have been unanimously selected as a caretaker.
Oh, who is for 8? Mr. Mazumdar, who is for 8? S.U. Ahmed, A. Hawari, where is respondent by
Last
8?
opposition also, they did not appear.
Where is Mr. S.U. Ahmed? A. Hawari. Heart 3, L.R.
A. Jeddah.
Your agent Ahmed?
Yes.
Heart 3, agent Ahmed, learned counsel for the petitioner. Full stop. 3, para. 3, I. Botakur, learned standing counsel, PHE. Praise for. And is granted further 3 weeks time to file affidavit, to receive instructions, / file affidavit in opposition. The learned counsel for the respondent number 8 is however not present. Full stop. The said respondent number 8 may also file affidavit in the meantime. Okay, next.
Please, your lordship, Mr. K.K. Mahanta is on his way, lordship.
One side is present, the other side is not. Next time the court will not be present. Then what will you do?
Lordship, he is in the bar, lordship, he is coming.
Should be here. Yes, what is the matter, Mr. Dutta?
Lordship, in this case, Lordship, they have challenged the decision of the APSC for rejecting their candidature on the ground of defective EWS certificate, Lordship.
Okay.
As per Lordship, policy of the government and the OM by the Central Government Personnel Department, which was adopted by Government of Assam, that any EWS certificate is to be valid for this current advertisement year, financial year, and it is to be related to the incomes and expenditure of previous financial year, Lordship.
Oh, that is the
This is okay. And the excess certificate which has been found submitted by the petitioner.
EWS.
Yes, like in that aspect.
My lord, in that case, there are allegations also. The private respondents, they have appeared by way of impleading the parties, my lord. The EWS certificate were filed after the passing over of advertisement date, your lord. They were not during the financial year.
Who are for the private respondents? Madam, how do you meet the allegation?
Not all the respondents. Not all the respondents.
Few are
respondents.
agreeing.
Few respondents.
Then what will happen to those few?
But Lordship, there's no fault on our part also, Your Lordship.
Why?
The advertisement was issued, then we applied, we got selected, we scored well, we were working till then, since then, Your Lordship.
No,
And
what
after
about the
we-
EWS? He
Sorry.
says that there has been delay in submission of the EWS.
As per the OM dated, Your Lordship, 10/4/2019, the financial year should be prior to the application year. And according to that, some of the petitioners have qualified, Your Lordship, but that is after Department.
Petitioners or some of the respondents? Some of the petitioners or some of the respondents? You
No,
said some of the petitioners, you said. You should say something, some of the respondents. Okay, we can take up the matter, yes, if you're all ready.
Wait, please, Lordship. Lordship, before I take your Lordship to the fact, 2 orders I'd like to point out, which the Honorable Court has passed. The first order the Lordship will take is order dated 19/9/2022. The first order issuing notice. 19/9/2022.
Yes.
May I read this slowly, Your Lordship?
Yes.
Heard so and so, also heard so and so.
No, read the relevant part.
Yes, Your Lordship. The respondent, third line, Your Lordship. Down below, the respondent in the APSC to file affidavit as to why, in the category of EWS, the petitioners having secured more marks were ignored, and other candidates having secured lesser marks were selected for appointment. Any selection or appointment that may be made shall be subject to the decision that may govern the present petition, and all appointments, if made, be made subject to the outcome of the present petition and the appointment orders to specifically mention that the appointments would be conditional, list after 2 weeks. So this was the status at that point of time when this writ petition was filed. There, at that moment, no appointments were made. Subsequently, Lordship, under order, before I take your Lordship to the facts, is pertinent here. Lordship will kindly take order dated 2/2/2023. This order was passed, Lordship, when the matter was heard. 2/2/2023. Coordinate bench of this court has passed the order. I will read it slowly, Lordship.
Yes.
2/2023. Second paragraph. The petitioners, 7 in total. Now, Lordship, it is 6. One has already been given job. Have approached this court, being aggrieved by non-inclusion of their names in the final select list of selected candidates for appointment in the post of junior engineer civil under the PNLD Department Assam on the alleged ground that the EWS certificate produced by them were not valid. Mr. So-and-so, for the writ petitioners, has argued that the ground on which the petitioners' candidatures have been rejected by the APAC is not at all tenable in the eyes of law. After hearing the submissions of so-and-so, I find that there is an interim order that so-and-so passed by this court in the present proceeding, observing that the appointments, if any, made during the pendency of this writ petition will be subject to further orders that may be passed in this case. However, what can also be seen is that if the petitioners succeed in this writ petition, they could displace up to 7 appointed candidates belonging to the EWS category. Notwithstanding the same, none of the EWS category candidates who have been appointed are parties to this proceeding. Therefore, if an order in favor of the petitioners is eventually passed by interfering with the appointments of some other candidates of EWS category, the same may be in violation of the principles of natural justice. Mr. So-and-so submits the list of names and other particulars of the EWS category candidates in order of merit are not available. Subsequently, Lordship, by this order, we have been directed to implead those respondents who have been appointed meanwhile. So those appointed respondents are from 7 to 28. And my learned friend appears for them. This is the current scenario. Now, Lordship, I will take you, your Lordship, to the facts of the case. Lordship, can you take up the petition now? Lordship, by an advertisement dated 24/6/2020. And Lordship, meanwhile, will also record one important date that by an amendment of Constitution 103rd Amendment, this EWS was brought in under Article 15, subclause 6. And that date, your Lordship, that date, Lordship may like to note, is 14/1/19. That is pertinent. The concept of EWS was first introduced and was brought in by the amendment of the 103rd Amendment of the Constitution of India, which is 14/1/19.
In Article 15?
Yes, your Lordship, 15, subclause 6.
Yes.
For the first time. This may be. Now, subsequently, this advertisement was brought in the year 2020. The date is 24/6/2020. Where 344 posts were advertised for the post of junior engineer civil under PNLD department. Their Lordship, out of 344 posts, 33 posts were reserved for the EWS category. That may be marked. Now, Lordship will find the advertisement at page 35, annexure 2.
Yes.
Now, what has happened, your Lordship? This petitioner, this set of petitioners who are before your Lordship, applied for this and they were called for verification. They were called for 2 rounds of verification, which your Lordship will find. And there, Lordship, one more point I'd like to point out in the advertisement. Lordship will kindly turn to page 40.
40.
Yes, your Lord. Page 40, Lordship, serial number 9.
Yes.
There, Lordship, only one thing is pointed out, that the BPL certificate stored EWS certificate wherever necessary. So this is the only indication in accordance with the advertisement that EWS certificates will be taken up. No further indication as to how the EWS certificate has to be issued or has to be taken up was given in the advertisement. This I say because that point may be taken up by the learned friend of mine. Now, your lordship, will kindly take up Annexure 3, page 42.
42.
Their lordship, this set of petitioners were called for verification. My roll numbers find place there.
Just a minute.
Yes, sir.
42.
Page 42, Annexure 3.
What is this?
This is the candidates bearing the following roll numbers are hereby informed to attend the office of the Assam Public Service Commission, Jawaharnagar, Khanapara, for verification of documents in connection with recruitment to the post of Junior Engineer Civil under PNA Department. So I've been called for interview. My roll numbers are there in this list. Then subsequently, again, the lordship will turn to Annexure 4, page 44. Another set of candidates, the petitioners from herein, were also called for verification of their document.
Next page, what you said, 40, after 42, 44.
Yes, your lordship, 44.
Similar.
This is same. Some name of the petitioners here also reflect. They were called for verification of their documents.
Then what happened?
And subsequently, also will take up Annexure 9.
Page.
This is the result. This is the result sheet.
Page.
Page 53, your lordship. Annexure 9, page 53. There, your lordship will find in the first part of the result sheet, the commission completed the process of selection and recommended the following candidates for a said post on the basis of merit.
Yes.
Here, lordship, my names does not reflect. The reason being, then I subsequently approached this honorable court.
Yes.
And this honorable court will take up page 62, Annexure 10. This is the second time this petition has approached this honorable court. Prior to that, this petition was filed in the name of 62, your lordship, Annexure 10. I'll read it slowly from serial number 2, your lordship.
Just a minute.
Paragraph 2. Operating party 63. May I read it slowly, your lordship?
Just a minute.
From para 2, your lordship.
Just a minute. Just a minute.
Yes.
4441.
Yes, your lord. 4441, 2020. Operating party is page 63, paragraph 2.
Yes.
All the petitioners herein.
Yes.
Yes. All the petitioners herein had participated in a selection process for the post of Junior Engineer Civil under the PNRD Department of the Government of Assam as per the advertisement dated 24/6/2020 issued by the APSC. The result of the said selection process was published by the APSC as per the declared result dated 31/5/2022. The result declared provides that the APSC declares the result of the recruitment to the post of Junior Engineer Civil of the PNA Department as per the advertisement dated 24/6/2020, for which the screening test was held on 27/12/2020.
Yes.
And after completing the process of selection, the APSC recommends the candidates stated therein in order of merit. Mr. So-and-so, for the petitioners refers to the provision of Rule 6D of the Assam Panchayat and Rural Development Officers Service Rules 2015, which inter alia provides that a direct recruitment to the cadre shall be made on the basis of the recommendation made by the APSC, and in doing so, the APSC shall furnish to the appointing authority a list of candidates recommended by it in order of merit in accordance with the aggregate marks obtained by each candidate found suitable for direct recruitment. By referring to the said provisions, it is a summation of so-and-so for the petitioners. The result published on 31/5/2022 also ought to have contained the aggregate mark obtained by the respective candidates. In view of such limited submission, we direct the APSC to issue a corrigendum result maintaining the result published on 31/5/2022 to provide the respective aggregate marks obtained by the candidate. The result may be acted upon by the authorities immediately after publication of the corrigendum. Mr. So-and-so, for the petitioners, refers to a notice of the APSC dated 7/3/2022 containing certain roll numbers of the candidates and requiring such candidates to attend the office of the APSC for verification of documents. The provision of the notice without the roll numbers is extracted as below. This was the extracted lordship. Then lordship will turn to the next page. By referring to the said notice, it is submission of the learned senior counsel that the notice also ought to have contained the respective marks obtained by the candidates whose roll numbers appear in the notice, so as to enable the petitioners to verify the same. Although we have accepted that the aggregate marks of the respective candidates be also included in the final select list on merit published by the APSC, but no provision of law has been brought to the notice that every intermediate stage of the selection, the respective marks obtained by the candidate at that stage would also have to be indicated in any notice that may be issued for any purpose. Further, we take note that the notice dated 7/3/2022 relates to an intermediate stage where the roll numbers of some candidates were mentioned and they were required to attend the office of the APSC for verification of documents. In the absence of any specific provision being shown requiring the indication of the marks obtained by the candidates, even at such intermediate stage of the selection, we are unable to accept the contention that the notice dated so and so also ought to have contained the marks of the respective candidates. No purpose would be served by also providing the marks in the notice dated 7/3/2022, and in order to protect the rights of the petitioners, it has already been ordered that the aggregate marks obtained by the respective candidates in the final select list in order of merit be indicated. The repetition is allowed to the extent as indicated above. Then subsequently, Lordship, by this order, the APSC published those mark sheet, the result sheet afresh by indicating the aggregate mark. Then, Your Lordship, this is the Annexure 66, page 66, Annexure 11 is the fresh result sheet showing the aggregate marks. Dated 29 July 2022. Page 66.
Yes.
Then subsequently, Lordship, the set of petitioners before Your Lordship file an RTI. This RTI is, Lordship will find it Annexure 12 series, page 75. The first RTI belongs to petition number 1. I'll not press for this because she has already been appointed in some other department. So Lordship will take up second page 76, petition number 2. Dear Lordship, the petitioner number 2 has received attained marks, which is 125.25. And Lordship will kindly note here.
Just a minute.
Yes, sir.
76.
76 is petition number 2.
RTI.
Yes, sir. To RTI information.
Yes.
So we wanted to inquire before the APSC that how well we have scored. And by way of that, this RTI was filed. And wherein they have replied to us saying that we have scored. Lordship will find period number 1, 125.25. Now, Lordship will also kindly note the cutoff in this category of the EWS is 113.25. The cutoff is 113.25. So we have received more than the cutoff, which is 125.
No, Mr. Mahanta, let us come to the main issue.
No, Lordship, what has happened? I stand.
No, we'll hear you.
Yes,
but,
sir.
What has transpired that you claim to have secured more marks than the last marks obtained in a EWS category.
Yes.
They are finding fault with your EWS certificate.
Yes, Your Lordship.
Let us concentrate on
Please,
that.
Your Lordship. Please.
These are all admitted. These not have any bearing.
Please, Your Lordship.
We are accepting that you have scored more marks.
Yes, Your Lordship.
We have to now find the justiciability of their action.
Yes,
so
sir.
far as in spite of obtaining more marks,
Yes, sir.
you have not been considered for appointment. That is the issue.
Lordship will kindly take up. Lordship, Annexure 1.
Annexure 1.
Annexure 1. And these are the EWS certificates issued to the petitioner.
Not one, I probably, or what? One of what?
One of the petition.
Petition.
Yes, sir.
Page?
Page 24. Lordship will kindly take up page 26.
Okay, 24.
24. This Lordship may skip.
Okay.
And before
Yes.
that, Lordship will kindly note the advertisement, the last date to appear apply in the advertisement, which was
That was the advertisement is of 24/6/2020.
yes, Your Lordship.
Okay.
And the last date was 28. 38.
Doesn't matter.
Yes,
Does
sir.
it? Okay.
Lordship will find it page 39,
Yes.
clause G. The last date of submission. Your Lordship, page 26 is my Page 27 now. 27 is the EWS certificate issued to the petitioner number.
Yes, this is dated what?
This is dated 10/7/2020.
No, 6/12/19.
The first one is 16/12/19.
No, we're at page 26.
Page, yes, page 26, the date of
6/12,
16/12/19.
not 16, 6.
6/12. I stand corrected.
And this is what you tell, valid for the year?
Valid for the year 1920.
Oh,
So this is a certificate issued by the Circle Officer, Additional Revenue Circle.
okay.
So on the basis of this certificate, we have applied for the said post.
But this Chanika Fukan, I think she has already appointed.
Yes, sir.
So let us come to the other one.
Other one.
Okay. P1 may not be very relevant.
Yes, sir. Also take up page 28.
Two eight. Let us come to the original.
Yes, sir. It's page 30.
30.
30.
This is number, so Savanka Saikya is number what?
This is petition number 3, Your Lordship.
30 is 3.
Yes, Your Lordship. 30 is 3.
We'll continue.
Yes, Your Lordship.
You concentrate on the main issue. Mr.
Yes, Your
Mark.
Lordship.
Marks is not the issue here.
Yes, Your Lordship. Consideration of the certificate.
আপোনালোকে শেষ কৰি লওক আৰু আমি কেইটা
Piecemeal.
Piecemeal. They are representing the private respondent who have been subsequently appointed.
Mr. Mahanto, Junior Mahanto has almost placed the facts, but the issue which is involved
Yes.
on the validity or otherwise of the EWS that she has not addressed as yet. We can do one thing, we can have this for further hearing, that you can submit in presence of Mr. Chaudhary.
Yeah. we can also do that.
Otherwise, we are
Yes, facts lost.
background facts.
Yes.
okay.
Now the question of law under.
Oh, yes,
whether-
yes, that is the issue.
Yeah.
That issue is not addressed at all.
Yeah.
To be very precise, that your contention is that you belong to the EWS category.
Yes.
And from the RTI reply, which you have obtained, you have come to know that you have secured more marks
Yes.
than persons who have been offered the appointment. You have been left out. And now we will see the justification by the department. Private respondents may not have much to say,
Yes.
other than to defend their own selection and their certificates. But why your certificates have been discarded, those have to be, I think they'll have to, who is appearing for the department? This is which department?
Department is PWD, PNRT. Basically, my lord, the electing authority is the APS.
There?
APS.
APS. But the EWS, the consideration for EWS, who will make the consideration?
APS.
APSC.
Yes.
APSC who was there?
But so far as the model department is concerned, though I am the administrative department, personnel will be more appropriate.
Yes, you're correct. Person, Mr. Chutia would be appealing, I think.
Your Lordship, basically, we need clarification from the APSC owner.
Mr. Chutia, ultimately the interpretation regarding EWS has the role of the personnel department will also be important. We'll do one thing, we'll have this on Tuesday next.
Yeah.
Tuesday or,
Tuesday.
not tomorrow, then Thursday also, it's possible.
Thursday.
Madam, Mr. Chaudhary will be there on Thursday?
Friday, Your Lordship.
Next Monday. Hearing this Thursday. Thursday.
Today is Monday, my lord.
This Thursday? He'll be there or not, Thursday?
Ek tarikh da? Ek tarikh.
We can have on Thursday or you can have on Monday next, whenever.
Monday.
Not Monday.
On done in the Tuesday.
Thursday.
No, or Thursday or Tuesday, this 2 days.
No, but motion day also will not make any difference. In fact, motion days, the matters are over very soon. Have it on Monday.
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 Yes, let them come prepared
Yes, yes.
for further hearing.
And personnel department take instructions.
Monday law.
Monday.
Yes, Monday.
This matter. No, this matter was heard at for some time today. But so, however, a prayer for adjournment has been made on behalf of Sri K. N. Chaudhary, London Senior Counsel, for the private respondents. Full stop, parents. Considering the above, let the matter be listed for consideration on
Monday, 5th of August.
5/8. Okay.
Deeply obliged.
For further hearing, well.
We'll have this.
In the meantime, my lord, I will have to update something from personal department.
Yes, yes. Para, since the issue is with regard to the validity of the EWS certificate of the petitioners which have been discarded, the views of the personnel department would also be necessary, along with the views of the APSC and the parent department, namely PNRD.
They already contact.
PNRD country.
I don't know.
Deeply.
May please, my lord. Also, first of all, I'd like to apologize for now.
Doesn't matter. Yes.
My lord,
Somebody was here.
on the last occasion, the records were called for. And I have just received the records, my lord. And my lord, my lord may fix it on a hearing day. The additional AG, Mr. P. N. Goswami is gonna do the matter.
Then Thursday.
My
Lord,
lord,
this is probably the 6th time
Okay,
my
Thursday.
learned friend is
No, my
praying
lord.
for an adjournment on that count.
No,
Thursday.
This Thursday,
Yes. Thursday.
my lord.
it'll come up for hearing.
No, it will come up for admission. We'll remember this matter. What was the issue?
Matter relates to pension, payment of pension and death cum retirement benefits to 32 numbers of master roll workers who were subsequently regularized
In the APDCL.
in the APDC. Similarly situated persons has been given benefit.
Heard Sri P. Bhumik Learned Counsel for the petitioners. What's the para? Sri S.P. Sharma, Learned Counsel, Learned Standing Counsel, APDC, has however requested for a short accommodation on behalf of Sri P. N. Goswami, Learned AAG. What's the para? In the interest of justice, matter is adjourned to be listed on first of August.
Right.
One.
Please, Your Lordship. I'll file my affidavit.
You have
today.
filed.
No, Lordship, I am going to file, it is on the process, Lordship, maybe during the course of the day or by tomorrow it will come.
Okay, madam, you take instructions. Okay. S. Dasgupta, heard Miss S. Dasgupta, learned counsel for the petitioner. Para. Miss M. Kotoki, learned counsel for the department. Veterinary and H and veterinary department. However, submits that the affidavit in opposition is being filed during the course of the day. Para. List this case on Friday next, along with the affidavit in opposition. Yes, Mr. Sharma.
Lordship, in this case, Lordship, the case of the petitioner was earlier considered by judgment and order dated 9/8/2023.
Notice was issued. Where is the response?
Essentially rejected, Lordship, due to Lordship, non-availability of vacancies, Lordship. Lack of vacancies, Lordship. On 2020, Lordship, it was rejected, Lordship.
You have come in 24. Why?
24.
No, Lordship.
On
Your Lordship may kindly find page number 52. This is the judgment passed by this honorable court in the earlier round of litigation, Lordship. The petitioner approached before this honorable court in the year 2020, Lordship.
20.
Yes, Your Lordship.
20.
When the claim of the petitioner has been rejected, but not considered in terms of the recommendation that has been made by the DLC in terms of Lordship OM, which is to be applicable in the case of the petitioner, Lordship.
1853. What was the order?
Order was to be considered the case of the petitioner in terms of the Lordship OM dated. Your Lordship will find that Lordship page number 58. Page relevant parties, Lordship, page number 58. May I read, Lordship? Paragraph 9. In terms of with the said office memorandum, although the reservation on account of compassionate appointment was limited to 5% of the vacancies occurring in a year, but it was mandated that the said restriction will, however, not apply where only one vacancy is to be filled up in a year. And as such, the department can appoint one person on compassionate ground against 5% quota up to 20% of the vacancy in a year, Lordship. Therefore, and this order was passed in terms of the Lordship recommendation that was made by the Lordship DLC. Your Lordship will find at page number 34. Relevant parties, Lordship, page number 38, Lordship.
38.
Yes. And page number 37, part 2 is there, Lordship. If your Lordship may kindly come page number 37 first. 2015, year 2015, numbers of vacancy 2, eligible vacant post nil. Number of vacant post in grade 4 is Lordship 1, eligible vacant post 1, grade 4, Lordship. Your Lordship will find at.
Now, what is your grievance, Mr. Sharma?
Grievance is that, Lordship, since there is one vacancy and the recommendation has been made by the DLC against the Lordship one vacancy that can be filled up in terms of the OM, Lordship, and that was overruled by by this honorable court, and accordingly one person has been appointed. 2 person has been recommended. One is Kamal Krishna Talukdar. In another round of litigation, his writ petition was allowed. That was also relied. Lordship retorted in the judgment passed by this honorable court on 8/9/2023, Lordship. Your lordship may kindly come to the judgment, lordship, page number
No, page
50.
63, the recommendation, consideration by the SLC has come to a finding that there is no vacancy.
But the lordship, your lordship may kindly find page number 63. Though there was an observation by this Honorable High Court, lordship, but same thing has been reiterated by the SLC, lordship. Your lordship will find 5% of the vacancy in class 3
No,
and
that-
class 4 post.
That is the OM.
No, that is the OM that is not exactly applicable to the case of the petitioner.
Why?
Lordship,
Why is it not applicable?
your lordship will find because this OM is not applicable in terms of the lordship Supreme Court direction passed in state of Madhya Pradesh and others versus Amit Srivastava and Indian Bank of and others and Promila.
Well,
In that judgment, lordship, if a person person died in the year 2015, if the government has lordship one OM that has been introduced and that was prevailing at that time 2015. Now, when the case of the petitioner has been considered in the year 2019, now new OM has been introduced by this government. That new OM that cannot be applied in the case of the petitioner, because the person when died at that time of which OM was applied, that provision should be applied to the case of the petitioner, lordship.
when was the death?
Lordship, death certificate I have enclosed.
Death is of 2014.
Yes, your lordship.
At that time, what was the OM which was applicable?
Your lordship will find OM
2009.
2009.
Yes, your lordship. In 2009 OM, lordship, that lordship bar was not there.
Which bar?
5% up to 5% reserve, maximum 5%. That binding was not there, lordship. Your lordship will find a page number.
No. Let us see the OM.
Your lordship will kindly.
What was the reservation then?
Lordship.
What was the reservation?
5% reservation for the lordship compassionate appointment out of an entire post, lordship, in a district. Lordship, but in the case of if there was only one vacancy to be filled up in a year, then in that case, lordship, that 5% reservation policy that will not apply. Because the OM itself says these things, lordship.
Let us see the OM.
Lordship.
Let us see how it says.
Lordship. Page number 58, lordship.
Yes.
OM has been, lordship, reiterated in the judgment, lordship.
58.
Yes, your lordship.
Yes, please.
State government had adopted a scheme by OM dated OM number so and so, dated so and so, as amended by number so and so, dated so and so, and dated number so and so, dated 8/4/1996 notification. So 11/10/2006 to give appointment on compassionate ground to the widow or son or unmarried daughter or adopted son, adopted unmarried daughter of a government servant who dies in harness with the view to give immediate financial assistance to the family of deceased in a class 3 or class 4 post not above the level of LD assistant, limiting in such appointment to 5% vacancies occurring in the year. The restriction will, however, not apply where only one vacancy is to be filled up in a year. Thus, the department can appoint one person on compassionate ground against 5% quota up to 20% vacancy in a year, lordship. This is the OM, and that was relied by the lordship DLC.
No, but this is 2009.
Yes, your lordship.
Okay, you file your response. He's raising some contentious issues. File your response soon. Will matter which 24. File your response.
Not sir.
Heard Sri D. Sharma, learned counsel for the petitioner. Para. Sri A. Chakraborty, learned state counsel. Praise for, and is granted 3 weeks' time to file the affidavit in opposition.
Highly available. But the debt by the fees. Because
List on 21st of August.
highly available.
My lord, relating to promotion from grade 4 to grade 3 died, my lord. Another director of SCRT. My lord,
Yes,
May I please lordship? Lordship, I'm appearing on behalf of respondent number 3, 4, and 5, lordship.
who are 3, 4, and 5?
Lordship, they are promoted.
they are promoted.
Their promotion is being challenged.
No, yes, who's for the department?
I'm responding for one, your lordship.
Your response?
Yeah, yet to receive the instructions. your
That is,
lordship.
and you also file affidavit, you
Yes,
have, okay. Third, Ms. B. Devi Learned Counsel for the petitioner. Full stop. Petitioner. In this case, notice was issued on 6/3/2024. Full stop. Ms. Teranpi Learned Standing Counsel, Education Department. Appearing for the respondables 2 and 3, 1 and 2.
Only one, your lord.
Only one. 2 SCRT.
But-
Your got the instructions.
No, your lordship. Lordship, may kindly allow some time.
Okay. Ms. S. Terangpil and Counsel for Respond number 1. Ms. What Bothakur?
Appearing on behalf of Mr. P. Nayak.
Initials, what Bothakur?
A. Bothakur.
A. Bothakur. Learned Counsel appearing on instruction of 3 P. Nayak, Learned Standing Counsel SCRT, and 3, your name?
And Madharpuya.
And a Mother Learned Counsel appearing for the private responsibles 3, 4, and 5.
5 years.
Pray for and are granted 3 weeks' time to file affidavit in opposition.
Okay, my lord, the time after
3 weeks.
you.
Yeah, please.
Yes.
Lordship, I appear on behalf of Mr. A.R. Tabildar, Lordship. He had to leave in some medical emergency.
Okay, have you filed affidavit, madam?
Yes, lordship. Kindly.
Affidavit filed.
No, lordship, we will file lordship.
Okay. While adjournment has been sought for on behalf of A.H. Tahbildar, Learned Counsel for the petitioner, comma, it appears that the response are yet to be filed. Para, on the prayer made on behalf of the respondents, comma, 3 weeks' time is granted to file affidavit in opposition.
Well, I'm obliged.
Me to the lordship, my lord, here the petitioner herein is the daughter of the second wife of the deceased person, my lord. Her birth certificate is at page
Yes,
24.
anything you'd like to say? Anything you'd like to say over?
Yes, may I please the lordship, I'm appearing for respondent number 8. Respondent number 8 is the first wife. We have filed our affidavit in opposition.
Yes, 13-6 you have filed with some
Yes,
record.
affidavit
Yes.
in opposition. So, lordship, my humble submission are in 2 folds. The first would be, it is a settled principle that unmarried.
No, he has not even opened his mouth.
Yes, since it's the.
No, we thought that you want to seek some adjournment or something. Let
My lord,
we'll hear your response.
Since it's the body.
in their affidavit, they have admitted, my lord, I am the daughter of the second wife.
So, can you tell us the facts?
The facts is this, my lord, I am the daughter of the second wife of late
Petitioner,
Ujjal Deori.
Daughter of second wife.
Second wife of late Ujjal Deori. Page 24, Annexure A.
24.
This is the birth certificate. Annexure A. Date
Yes.
of birth 23/9/2003. See Ujjal, father's name Ujjal Deori.
Okay.
Then, my lord, my wife filed an application for under section 125 CRPC against the father, where at page 30,
Oh, your mother had filed.
my mother had filed
Mother filed what?
an application under 125 CRPC.
125 application.
At page 30, your lordship will find last paragraph.
Father is still there or not?
No, father expired.
When did he pass away?
Date of is,
Okay, doesn't matter.
my lord, it is date is 2/5/23.
5/23. Okay, then, okay.
My lord, my application, my mother's application 125, judgment was delivered on 5/3/2013, page 30, relevant portion.
Yes.
Page 30, last part. The first party being contractual worker, nothing will depend upon the first party by Miss Queen Deory. It is the petitioner. She depend her father for a bright future. The innocent child did not know the fact of the world and the misunderstanding of the parties. She could not suffer her life. Hence, the second party is directed to deposit amount of rupees 5,000 per month in the name of Miss Queen Deory. In my name. I was getting 5,000 per month. At page 33, my lord, your lordship will find in Lok Adalat, it was increased to rupees 9,000. Page 33.
This amount is for you, daughter.
Mine, for me.
Increase that page.
33. Up to 9,000 rupees.
Okay.
Page 34 is the death certificate of my father. 2/5/23, left-hand side, second column. The first wife, the private respondent, at page 35, obtained a next to kin certificate without placing my name. And at page 36, your lordship will find the name of the first wife and the son is there. Page 36. Age 51 years and son 41 years. Page 36. Then at page 37, I made an representation to the district commissioner saying that I am one of the legal heir, so that kin certificate may not be acted upon. And the pension amount may not be disbursed to the first wife.
37.
Page 37. And the vernacular, page 38.
What is the date?
Date is, my lord, 9/11/2023.
Okay. Then
page 39, my lord, the officer in charge ICDP Lakhimpur informed the private respondent at page 39.
What was the deceased employee doing?
My lord, he was working as the petitioner, my lord, he was working in the office of the district commissioner, my lord. Veterinary department, he was working as
Okay.
At page 39, my lord, your lordship will find.
Yes, what is 39?
39, the officer in chief ICDP Lakhimpur has stated to the private respondent they could not proceed with the pension papers due to objection raised by the petitioner, daughter of such and such, who is dependent for her maintenance of her father's salary. So that pension papers were kept in abeyance.
Okay.
My lord, now I am studying in the, my lord, as a 4-year Bachelor of Technology, Department of Agriculture Engineering in Assam University. My lord, there is under the Pension and Public Grievance Department, in page 44, your lordship will find under Article 309 of the Constitution, the governor was pleased to make the following rules. Page 44. Amendment to Rule 143. My lord, here in the subclause 2A, in subclause Roman 1 in clause D, the word unmarried minor daughters shall be substituted by the words unmarried dependent daughter. Then, my lord, the proviso is there after B, provided the family pension shall be allowed to continue beyond 21 years of age to an unmarried dependent daughter of a government servant, pensioner, subject to the fulfillment of the following condition: that there is no disabled child eligible for the lifetime family pension, that a certificate of non-marriage and non-employment in the prescribed format duly certified by the CO, BDO concerned shall be furnished by the unmarried dependent daughter to the treasury or bank once in a year. And my lord, that certificate I have annexed at page 48. Page 48, I have annexed that certificate, my lord. Verified by the block development officer. That I am not
Page
married.
48.
Eight. Verified by the block development officer. I hereby declare I am not married. Signature, Miss Queen Devi, PPO, date 12/1/24. So I am entitled to get some share of the pension, madam. The second marriage may be not legitimate, but the daughter entitled to get. That is my submission before you. বললাম তো। 143.
The aspect of the legitimacy, isn't it required to be brought in approved in, established in a court of law?
My lord, regarding my lord, it is an admitted fact.
No, no, the offsprings of an illegitimate marriage will have these full rights,
No.
but that has to be proved.
No, but they have admitted, my lord. They have admitted, and my lord, by that judicial pronouncement of a court, it has also been
No,
admitted
that was for maintenance.
for maintenance. But it has been admitted that I am the child of the second wife.
No, that can be a supporting document for you, but
My lord.
unless, of course, if they have admitted
And in their affidavit,
that
my lord, they have
your
admitted.
your relationship with the deceased is of a parent and a child, then matter will be different. So far as legitimacy issue is concerned, there is no dispute. There is a provision of law
No
that
provision of law.
children of illegitimate marriage will have the same
My lord,
rights.
my lord.
The wife
They have
cannot have the
admitted in
right.
para 4.
Yes, who is for the authority? Yes, Mr. Chutia, are you for the authority? This is which department?
My lord, this. Hmm? Key department. Veterinary department.
Who is for veterinary department? Where is Mr. Kotoki?
Standing counsel.
This is item number?
50. Right to animal husbandry.
Oh, her name is not shown. Is the veterinary department a party or not?
Yes, yes, party man.
Response number 3. 5.
One also.
One out.
1 also. 1, 3, 5.
Oh, you should have pointed out. Mr. Kotoki, Miss Kotoki was here. Can somebody call her? Mr. Ralchaudhry? Can you
No,
inform
just now, Dhor was carrying the government file, madam.
No, he'll be for the pension department. He'll have a role definitely, but Kotoki will also, parent department, the administrative department also will have a role. But are you representing the pension department?
Pension.
What is your say? And what is your name? Mrs. Sen, you are for the private respondent. Okay, we'll hear you.
He is coming, my lord.
Otherwise, what is your stand? Mr. Chutia.
My lord, we have received one, my lord, instruction, private student from the district commissioner Dhamati. I think affidavit is not filed.
Affidavit not filed. Affidavit has been filed by the private respondent
Private
by
respondent, okay.
on 13/6. Your stand needs to be there.
Our state district commissioner, my lord, two paragraphs, my lord, otherwise, my lord. The application was received on 17/5/2023, submitted by Sri Gitali Deuri, wife of so. For issue of next skill certificate in the names of Timothy Gitali Deuri and Sri Sukolodhar Deuri, son of so Deuri, along with the other 11 documents being application according to the digitized next of the skill certificate was issued on application 7/6/2023 after receipt of the report from the conscious developer. Deputy Commissioner has issued mandate. The digitized next skill certificate bearing application shows consolidation money as per the application received from 19 submitted by Sri Queen Deuri, letter of let Ujjwal Deuri, and letter is issued to the first applicant Timothy Gitali Deuri on 27 March 2024 to submit a fresh application with the names of all kids let but two paragraphs only, Malad, these are the only thing. And others were departmental advocate. No. Okay.
Their name has not been shown by the veterinary, so they ballot inform me that he has prepared the affidavit, he is going to file the affidavit.
Okay. Mr. Sen, what is your stand? Are you admitting that the applicant, the petitioner, is the daughter of the deceased employee?
Lordship, our entire answer to this particular aspect would be there to this order of the honorable court, wherein in regard to this particular aspect, so that statement was there. So we are just.
Where is that order?
That 125 application, man.
That would be annexed in the this petition page number.
Are you referring to the 125 order?
Yes, yes.
How does it help you?
Like we are not admitting on that aspect. It's our standard. A certain court order has been passed in regard to this particular aspect, to which we are not going contrary to that.
So that in fact recognizes her right to even to for getting maintenance. Here, the second wife is not before us.
No.
Had the second wife come, our views would have been different. It is the daughter of the second wife. Her right perhaps would be at par with your right. Who are you? Are the first wife and the son. And the son.
Herein, only the first wife has been made a part.
Son is not a party.
Because the next kin certificate was was applied by the respondent number 8.
There are two names.
Two names, but
you could have, doesn't matter. We'll take care of it. You have already appeared for the son.
Yeah.
Oh, only the
eight.
Eight is the mother.
Mother. The next 15.
Okay. Let the affidavit by the veterinary department come. Okay. Heard. Sri P.K.R. Chaudhary. Learned counsel for the petitioner. Full stop. The petitioner claims to be the daughter of the second wife of the deceased employee, Ujjwal Deuri, who was employed ED with the animal husbandry and veterinary department. Full stop. The petitioner has relied upon the orders passed in a proceeding instituted under section 125 of the CRPC for maintenance, wherein the rights of the petitioner was recognized and maintenance was granted, which was also enhanced in a loka adalat. Full stop. However, on the deaths of the government servant, the next of kin certificate was obtained by the respondent number 8, the first wife, which excluded the name of the petitioner. Full stop. Para. While the private respondent number 8 has entered appearance and has also filed affidavit in opposition being represented by Sri T.R. Sen, learned counsel, comma, the administrative department, namely the Animal Husbandry and Veterinary Department, is yet to file its response, the response, full stop para. However, comma, a prayer has been made for grant of some time to file such affidavit in opposition. Full stop para. List after 3 weeks to enable the administrative department and to enable the, don't write administrative, Animal Husbandry and Veterinary Department to file the affidavit in opposition. Full stop. Let the name of Miss M. Kotoki, Learned Standing Counsel, be reflected in the cause list.
By an advertisement dated 17/3/2023, the election process was initiated for the filling of the post of the Mondals.
Yes, notice was issued.
Yes, my lord, we send a letter, my lord, we have not received any instructions, my lord.
Read the instructions.
Let me have instruction, my lord.
And anyone else appearing, Mr. Chotia?
No, my lord.
Revenue is there. Will you file response or will you depend on the? Okay, okay. Sri P.J. Saikia, Learned Counsel for the petitioners. In this case, wherein, etc. In this case, wherein notice was issued on 5/4/2024. Para. Sri T.C. Chotia, the learned additional senior advocate Assam, submits that instructions are awaited. Full stop. List after 3 weeks to obtain instructions / file affidavit in opposition. Sri S. Dotto, Learned Standing Counsel Revenue, is present.
Well, if possible, well, kindly fix a date, Mal.
What is the matter about?
Matter, non completing the selection process. Whereas there is notification to complete the
List
process by people.
On 19th of August.
Hello. Oblige.
And here the challenge is to the parallel proceedings of a disciplinary proceeding and the police case, my lord.
Your surname is, there is some error in your surname. It should be Yadav. Mr. Chakraborty? I think there is some error in his surname. Suryakant Yadav.
Suryakant.
Should not be Morang. Sky.
Sky.
Yes, what does Sky wants from us?
My lord, a disciplinary proceeding and a criminal proceeding are running at the same time against me, my lord. My prayer in the repetition is that the disciplinary proceeding be stayed till the disposal of the criminal proceeding.
Yes, yes.
Lordship, extra copy yet to serve, Lordship.
Served them. And have you got Stanzen?
My lord, Stanzen is the, my lord, there was an earlier order, but
Totetsu.
not so there is no bar to, there is no bar to time.
There is no bar, but the last order of 2014, I think. What
But
is the
here
name?
the petitioner is the DSP. In that particular case, it was the SP, my lord. The same case, the same disciplinary proceeding, only the date of the show cause would defer to 27th of June. Otherwise, it is exactly the same thing. The same FIR, the same police case number, everything remains the same.
Toitetsu. Stanzen Toitetsu. 2014 years. Have you seen this order?
No, sir.
Have a look at Stanzen. We'll pass orders on Friday. We'll try to follow the same order. Give a copy. See, all the cases, earlier cases have been considered. Paul Anthony on those cases. And in the case of Stanzen, 1 year time has been given as the standard time to complete the, until 1 year it will be put on hold because he should not suffer any prejudice in the criminal case if he discloses the defense in the disciplinary proceeding. But that will not be for indefinite period, at least 1 year.
1 year.
You go through this.
We'll go.
Heard Sri Mazumdar, R. Mazumdar, Learned Counsel for the petitioner. For Sapkara, Sri A. Chakraborty, Learned State Council, however, praised for some time full stop para. Sri Muzumdar, the learned counsel submits that the issue involved is already resolved in a number of cases. And in this regard, he has also placed on record an order passed by this court wherein the cases decided by the Honorable Supreme Court have also been cited. Full stop para. और ये चक्रवर्ती ऊपर वाला मत लिखो, अभी लिखना, हाँ, और इनका कंटिन्यू कर देना मजुमदार को. Sri Chakraborty, the learned state council, A Chakraborty, the learned state council, prays for some time to go through the aforesaid order. Full stop para. List on Friday or Monday? Friday. Friday. Okay. Let's wait for list on Friday. You can bring, if you are saying that it's the same proceeding, you can make a correction and pencil in one of these order.
I'll do
it. Before that, you have show it to Mr. Chakraborty. Mr. Chakraborty, have a look at this order.
Bless. Oh, bless.
Yes.
My lord, we have received the parallel instruction, my lord. Principal kindly grant me some
What
time.
is the matter?
My lord, with regard to pay penalty, my lord. We have received the
Let
detailed
us, you work as what?
Yes, my lord, let them file a,
Now, you work as what? Home guard?
yes, my lord, petitioner is appointed to the class 1 junior grade as a home guard services at the state, my lord, seeking payability to the junior grade Assam police services.
Okay.
petitioners are agreed by my lord, by an order, my lord, passed by the administrative department, thereby negating their claim. So will be our affidavit.
Hearts will be the learned counsel for the petitioner. Full stop para. You are for the finance department.
My lord.
Para nahi. Learned counsel for the petitioner who has raised the issue of pay parity. Full stop para. Sri R. Majumdar. Sorry, Sri R. Borpujari. Learned standing counsel, finance department. However, prays for and is granted 3 weeks time to file the affidavit of opposition.
I'm obliged.
I'm so obliged.
May plus, whatever notice has been issued. Notice also was issued, my lord. The respondents also appeared now. Here the since November 2008 pension of the
Affidavit filed.
no, my lord.
No, my lord, I have received instructions, but I was comment.
Nandi for whom?
I am for the bank. Yeah,
Which bank?
State Bank.
Who will take the decision?
Central processing cell, pension cell.
Okay, Mr. Doctor.
And we have.
You are the nodal, you are the, whatever they will direct, you will do.
Yeah, whatever they will direct, we will pay. But main
Mr.
is
Doctor, your response?
My lord, another aspect is that.
Have you received the parawise comments?
Parawise comment.
Oh, you filed the affidavit.
But,
But pension matter, you hurry up. Pension matter.
Pension matter.
Okay.
The media.
they have to take instruction because everything was forwarded to them.
Heard Sri B. Sana, learned counsel for the petitioner. Full stop. Sri A.K. Datta, learned CGC, appearing for the respondent was 1, 2, and 3. Submits that instructions have been received.
yes, Parawise comment.
Parawise comments have been received. And he would be filing the affidavit in opposition soon. Para. Sri Nandi. K.K. Nandi, learned counsel for the State Bank of India, has however submitted that it is the respondent was 1, 2, and 3 whose response would be necessary, would be relevant in this issue. Full stop para. On the prayer of Sri Datta, done in CGC. Matter is adjourned by 3 weeks. to enable him to file the affidavit in opposition. Full stop. List on, we give a date, mention
Yes,
matter.
yes, madam.
List on 29, 1, 2, 3, on 21st of August.
Obliged.
My lord, one aspect is that the response number 2 is not dealing with the matter. The PCDF, principal controller. of
Whoever
the-
is dealing, we file through them. No, don't worry. Yes, next.
Lot, matter relates to payment of arrear salary lot. The pension payments have already been paid to retired employees of Fishware. But for arrear salary lot, fund demand has been moved and it will be sent to the finance department shortly. Lot, things are in process.
It's a matter of 2022, Mr. Botakur.
Lordship, one important part was that the records had to be retrieved, Lordship. So that took some time.
And 9/4, you are given time. Your
Okay.
submission which you are making today
Yes, sir.
were taken into consideration that payment of leave salary and gratuity,
Lord.
those part, and 4 weeks time was granted to you to provide up-to-date instructions on the aspect of arrear salaries.
Lordship. And
You advise your client to expedite the
Lord.
movement. Otherwise, contempt matter, difficulty. What is your name, madam?
Elmar,
El Bharali.
Elmar, HMAR.
Mar. Okay. Which part of NCL do you reside?
Haflong.
Haflong. Okay. What is the passion of Mar people? Stone cutting. Isn't it? If you find a rock, you'll start to cut. Miss Elmar, learned counsel for the petitioner. Para. Sri I. Botakur, learned counsel, submits that the aspect of arrear salaries, submits that so far as the aspect of arrear salaries are concerned, comma, steps are being taken, full stop, para. He accordingly prays for and is granted 3 weeks further time to obtain the latest instructions and the progress achieved. Instruct your client. Okay, please after 3 weeks.
Okay.
Sir, office was dated 17/7, service of the respondent number 5 already completed. It is the matter for admission, madam.
You have for 5.
No, I,
1, 2,
we
3,
are
4.
1, 2, 3, 4, my lord.
Who are 1, 2, 3, 4?
Food Corporation of
Food
India.
Corporation is, I'm on behalf of my senior BK Singh, Standing Council of FCI.
Okay.
We are for the respondent 1, 2, 3, 4. And 5. I
You'd
don't-
like to file affidavit?
Already
No,
filed,
yeah,
madam.
we have already filed that.
I have to
Ah,
file a reply, madam.
okay.
Uh,
You like to file reply? Okay. Heard Sri K.R. Padgiri, learned counsel for the petitioners, who by referring to the order dated 17/7/2024 of the Learned Law Zima Court has submitted that service upon the respondent number 5 is complete. Full stop. The said order has been perused and the service upon the respondent number 5 is accepted to be complete. Full stop. The FCI authorities, namely respondent numbers 1, 2, 3, and 4, have filed affidavit in opposition. Full stop. Sri Padgiri, the learned counsel for the petitioners, prays for, and is granted 3 weeks time to file rejoinder affidavit.
Obliged.
In the meantime, comma, The respondent number 5 may also appear through counsel. May also appear and file affidavit in opposition if so advised.
my lord. Oblige.
No, please, your lordship, I have filed IR civil for.
IR for?
Simply the present incumbent, lordship.
This one, present one.
Yes, lordship. Filing number.
Oh, today you
850
file another IA. Now, what is this IA?
Lordship,
In the meantime, I have received instructions, Lordship.
What does it say?
Excuse me kindly.
What does it say?
That, in the second DLC meeting, dated 7th and 17th. Last paragraph, Lordship.
Hmm.
Her representation for completion and appointment could not be considered and rejected the same as per Principle 6 OM dated 1/6/15, citing reason that petitioner's mother is a government employee.
Order also expired, lordship.
Murder has expired. Director of Health Services doesn't make any inquiry before giving the parawise comment.
When he died?
When did your mother pass away?
I forgot, lordship, actually.
Is it recently?
No, 2019, maybe 2019.
19, then why is this coming? 2024, mother is a government employee. You can take a ground that your mother, her mother was also a government employee. But this gives the wrong impression.
Yeah.
Director writes to you without any. Mother was working in which department?
Same department.
That is even worse. Same department, she is employed, you don't even know.
It's the DLC meeting, no, Lordship? Second DLC meeting.
It's not a question of DLC, it's a question of the communication given to you by the Director of Health Services.
Yes, sir.
He says that one of the employees, at least his duty was there to communicate to the DLC that mother had passed away in 2019. After that, if they take a decision, that's a different matter.
I think it is not in the.
You take and who is for the DLC? Health Department. Yes, Mr. Tutia. See, compassionate appointment, you may not be too much with the petitioner, but we need a fair consideration. Delay part, everything will take care. The present law, but he or she needs to be dealt with fairly. Now DLC has rejected, and as per the instruction obtained by Madam, the instruction is that mother of the petitioner is also a government servant. That's a very valid ground, but council says the mother passed away in 2019. So that is not proper.
But I will keep alert. I don't have the file.
No, we'll give you some time. Okay. What is your name?
Gigi Gogol.
Gigi.
Yes.
Her Gigi Gogol, Learned Counsel for the petitioner who submits that an IA has been filed today.
Today, lordship.
Today, which today puts up. Let such IA be listed along with this writ petition in on Monday next.
Yes, sir.
Monday next. Para. Miss D. Bora, Learned Standing Council, Health and Family Welfare Department, has, however, placed on record a copy of the written instructions dated 5/2/2024, issued by the Director of Health Services, as per which the rejection is on account of the mother of the petitioner being a government employee. Full stop. The Learned Counsel for the petitioner has, however, clarified that the mother of the petitioner had passed away in the year 2019.
Yes, Lord.
Full stop, para. Let fresh instructions be taken by Miss Bora, the Learned Standing Council. Para. Sri Chutia, TC Chutia, the Learned Additional Senior Advocate Assam, would also obtain necessary instructions. Full stop. Para. List after 3 weeks.
First Lord.
Next 59.
Not if it takes we have already sent a letter. Perhaps the letter is not reached to the person who come to Guwahati for affidavit.
Okay, you have otherwise affidavit is ready.
Ready, my lord.
Okay, let them file affidavit, Mr. Masud.
Yes, 2 weeks time at least.
Okay.
Run for it.
Sri T.C. Chutia, learned additional senior advocate, submits that the affidavit in opposition is ready and would be filed shortly. Full stop. List after 2 weeks.
My lord, a date may be given the last week of August. My
What is the issue?
matter relates to the dismissal of the petitioner from service.
2 weeks. 60.
This case, my lord, respondent number 2 and 3 appeared, my lord. However, my lord, the state filed appeal before the division bench. Again, this order.
Regarding
My lord, still pending, my lord. Writ appeal number 59. Okay.
that gap period, balance period.
Yes, Lord.
Yes.
And one, you have to take complete new,
Yes, one has already retired, Lord.
one has
Okay.
retired.
Oh,
Malad.
And I think 2 and 3 are there. PNRD,
I'm waiting for 20.
these officers are still in the Panchayat and Rural Development. Okay. Sri Padgiri, K.R. Padgiri, Learned Counsel for the petitioner, has submitted that so far as the judgment, so far as the order involved in this contempt petition is concerned, the issue was raised by the state before the Honorable Division Bench, and there is an order of stay. Ms. M. Devi, Learned Counsel for the SP number 1, has submitted that her client has already superannuated from service. Full stop. Ms. N. Bora, Learned Counsel, is present for the SP numbers 2 and 3. Full stop. 3, in view of the submissions made, matter is deferred, consideration of this matter is deferred by 2 months. Full stop. In the meantime, the Learned Counsel for the petitioner may also file appropriate application for imprisonment after issuing notice to the present incumbent.
Your lordship, the contempt has already been complied with, your lordship. Right, order dated 19/4/2024 by the open side.
Sri K. Mira, Learned Counsel for the petitioner, has submitted that the order dated so-and-so, passed in WPC, so-and-so 959, asylum, has already been complied with. Full stop. In view of such submission, this court is of the view that there is no reason to continue with this proceeding. Full stop. Contempt petition accordingly stands closed. Thereafter.
That is a lot. Lordship, you have sent the affidavit for vetting, so we need further 2 weeks time to file the affidavit.
What is the matter, Mr. Madhu?
The case of termination from service. of
Get the records,
petition-
madam. LDB, Miss LDB, Learned Counsel, appearing on instruction of the Deputy Solicitor General of India, submits that the affidavit in opposition has been sent for vetting and would be filed shortly. Full stop. See accordingly prays for, and is granted 2 weeks, 2 further weeks to file the affidavit in opposition. The Learned Counsel for the respondent is also directed to procure the records of the disciplinary proceeding.
Pleasure. Item number 63. It's a matter of termination from service. I had gone through the records which were available for me. Many things are missing. I requested my friend, he has the records, official records. It's a general security force code. If Lordship allows me a day, I'll just go through the records to find out.
Matter of which year? 21, okay.
2021.
Okay, done.
21.
Sri R. Mazumdar, learned counsel for the petitioner, prays for some time to reconstruct his record. Full stop. Sri K.K. Parashar, learned CGC is present. Full stop. Para. List after a week.
Yes. Obliged.
May I please, Lord? My lord, the last question, my lord. Instruction was my lord served regarding my lord. Reduction of pay, my lord, from one stage from 46,200 to my lord 44,900, my lord. My lord, in this.
Yes,
Lordship, and last occasion, Lordship, court was inclined to know whether the penalty can be relaxed.
What is the penalty?
At page 114, my lord. At page 114.
114.
114, para 10.
Paragraph 10, yes.
My lord. Therefore, in respect of powers conferred upon me under Rule 52 of CI, is that rules to I have a confirmed order of penalty reduction of pay by one stage from 46,200 to 44,900 in the time scale of pay as per matrix level is for a period of 3 years. During the period of reduction, he will earn increments of pay that on spur reduction will not have the effect of postponing his future increments of pay. Yes, my lord, only grievance is, my lord, it is too harsh, my lord. If it is for 1 year, my lord, court may dispose, my lord, my way is very simple, my lord.
But it is
Because,
not-
because
it
my
is-
lord, I have complained regarding food. I have some stomach problem. I complained against the food served to me. So my lord, I demanded home cooked food. So I was apprised to my lord, my lord, the administration department where other persons are not allowed, my lord. That's why, my lord, I have submitted the my lord medical report, my lord. I have
Yes,
complained.
what is your instruction?
Because of that, my lord,
my Lordship, they are not agree with the relaxation because there is no postal improprieties there. Firstly, Lordship, and the penalty, it is like as per the department, it's not such a major penalty, Lordship.
It is not a cumulative effect. There is no reduction. During the reduction period, he will still under increments. It is one stage for 3 years.
And the petition has been filed in the year 2023.
I have that instruction, my lord. My lord, if it is, my lord, penalties for 1 year, my lord, I have no objection, my lord.
No, he is not agreeing. You have to argue on merits.
My lord, can you see page, my lord? Page 16, my lord.
Mr. Das, you have filed the affidavit.
Pardon, Lord?
You have filed affidavit.
Yes, Lord.
Staying in the, my lord, page 16, my lord.
16.
16.
Have your seat. Have your seat.
Yes, Lord. If my permitted, Lord, may I bring the CISF rules here? Lord?
Yes, yes.
Page 16, my lord.
16 is what? Yes, what is 16?
Yes, my lord. At page 16, my lord, your lordship see. Staying in the quarter of that family is not permissible under any circumstances. Hence, if the circumstances compel any allotted member to leave his family at the native place, he must obtain prior permission from the committed authority and stay in barrack till return of family. Violation of instruction will be viewed seriously and allotted order will be cancelled. This allotment order subject to acceptance of condition laid down in the standard and taken to be furnished by the allotters. We were taking possession of quarter from PM section. No civilians will be allowed to stay in the quarter, allowed to individual except the dependent members.
In case of temporary stay of guest relatives in the family quarter, prior approval must be obtained from competent authority. Reduce HRA in respect to above personally sanctioned or is hereby cancelled from the date of issue of quarter. Their order is issued in accordance with the decision taken in quarter allotment committee, so and so. So seal number 9 is directed to vacate X within 2 days from the date of issue of this allotment order. But thereafter, my lord, I was, my lord, allotment of next page, my lord, page 17. Allotment of family accommodation regarding the flowing CSF personnel, page 17, my lord. Of this unit have been allotted Gov family accommodation at Suraksanagar, South Bank, Moran, as per seniority. My name is at top, my lord, Anantanak, my lord, the present petitioner. Thereafter, my lord, I have, my lord, kindly see next page, my lord, 18, page 18, my lord. Most respectful prayers that I am force number Anandan is employed in the industry. Through this letter, I would like to know that the company company that deployed me along with other officials of the industrial sector at Jaradan outpost, which is under the field sector of the unit. As per the information, the company commander has authority over only the industrial sector, whoever the officials of the industrial sector are deployed by him. But Jaradan is not under his authority. In this regard, I would like to know that officials can be deployed at Jaradan sector to the company commander's order. With such order is a valid one. Will you be bound on me after notifying me I was deployed at Zorazan post? That, my lord, I have complained, my lord.
Show us the show cause notice.
My lord.
Come to the allegations.
My lord, yes.
Come to the allegations, list of allegations.
Yes. At page now, my lord. At page, my lord, 23, my lord. Page 23.
Yes.
I have complained, my lord, regarding, my lord, PA, DA, everything regarding food. I have complaining, my lord. Since now at page, my lord, page 25, my lord. Page 25. All pages, my lord, I will not read, but my lord. Para 5, my lord. Para 5, page 27. Para 5, page 27, my lord.
Yes.
27, my lord, para 5. The sector commander being himself the competent authority, the office order dated so and so was issued, but there were senior officers in the unit, and thus violating the rules and regulations CSF 2000 section 10A, the family members of the industrial sector, oil division, were deployed at Jaradan Airport. The family members of the force were allowed at GOP quarters, where the force members used to stay with their families so that they can discharge their routine duties. In the quarter allotment notice, it was not mentioned that the force members has to discharge their duty, leaving their families for 15 days outside the area of work. It is by provision that the force members are required to serve other than their sector, and they were officially deployed there, and the TAD allowances were given to them as per rules. But as per the order number so-and-so dated, so-and-so, we are deployed at Jordan and served there for 15 days, but we are not allowed to claim TADA for the period in spite of our being outside of our sector. Whereas after being allotted the family, the force members were able to take food together with their family. But after complete deployment of Zorazan, double expenditure had to be incurred by the force members for the food. I have complained the food, my lord, because I have some stomach problem, my lord. So I demanded, my lord, food, home cooked food from my quarter, my lord. The Jaradan outpost was 30 kilometers from the family quarters of the industrial sector, Duliazan. Therefore, as per the provision of TADA, the economic loss of the force member as a result of consumption of extra food at Jarazan, he might be allowed to avail TADA for 15 days as a compensation for those days he was deployed at Jarazan. It was mentioned in office number so issued by sector command that was the routine exercise the force members were deployed from the field sector to Jarazan outpost. In the previous case, also TADA was allowed to avail by the force members who were deployed at Jarazan outpost. As a proof of this, the record of 2002 might be verified. I have submitted a manual recommendation. Thereafter, my lord, At page, my lord, at page 40, my lord. Page 40. Nine is the my lord transfer copy, my lord. It's in Hindi, page 40. With reference to the above letter, this to inform you that force numbers.
Mr. Rahul, why don't you come to the main point?
Yes, my lord, I
Come to the
my
statement
lord,
allegation.
I have been complaining along.
That we have understood.
That's
that
why,
you've
my
been
lord.
complaining about quarter and your food. Come
Yeah.
to the list of
Now
allegations.
at page 41, my lord, can you see? Page,
40 pages you have gone through. without-
yes, 41, my lord.
What is
41 and 42, my lord. I have complained
41 is the medical prescription.
My
You
lord.
want us to read the medical prescription.
regarding my stomach problem, my lord.
Was it before or after the allegation?
It's not before the allegation, my lord.
Come to the allegation first. Let us have a look at the allegation.
Then, my lord, the report is at page, my lord, 44.
What report?
In initial investigation report, my lord. And it's page 44, my lord. The first paragraph, my lord, with
Yes.
only first paragraph, my lord. The force number so and so not of CICF division was deployed as Rajasthan outpost from dated so and so as per the inquiry order letter number industrial block letter number so and so dated 3/2000. The above force number submit an application at the sector office of CICF division regarding his daily allowance DA and the meal to send to him from his office quarter to the outpost and dated so and so. The force number used to continuously complain about the meal of the mess, and he made constant pressure on the department regarding the. Due to this reason, he was to remove from his Rajana outpost after 3 days only, thus without completing the stipulated 15 days duty at the post. To investigate above, the undersigned was assigned as primary investigating officer. There were, my lord, the whole, it's the, my lord, investigating report, my lord. Now, page 68, my lord. Page 68, para 2, my lord. The reply to the application submitted by the force member regarding TADA has not yet been received from the any regional headquarters of CICF Guwahati, but the force member repeatedly raised the issue and thus empowering the development of force members, deployment of force members at Joradan. As the sector office did not deal the matter and steering force member with full conscience made this appeal that the force member cannot disobey the deployment order, but looking at the petition of the force member, it has been observed that in previous case, so he used to put pressure on the sector office regarding his deployment of Joradan outpost. It is against the law and rules of the discipline force member to go for Hungary strike to establish his point. Hence, it has been found that a force member has disobeyed the direction of the force against him. The first case of indiscipline can be established. Thereafter, my lord, final order was passed, my lord. Enquiry report at page 65, my lord. It was submitted. Then the final order, my lord, at page 82, my lord. Everything has been mentioned, my lord, in page 82.
82. Yes. What is 82?
Last, my lord, last para.
This is one letter by you.
82, my lord. Yes. 84, my lord. The final order was passed, my lord. 84. Page 94, my lord, the operative portion, my lord. Page 94, para 4. The operative portion, my lord. I will not go in details, my lord.
94.
94, para 4.
Yes.
Therefore, after meticulous consideration of all the above aspects, I hold both the charges level against it as proof. Hence, I understand, in exercise of powers conferred upon me under Rule 32, read with conjunction under sub-rule 20 of CICF rules, I do hereby award the penalty of reduction of pay by 1 scales from reach 46,200 to 44,900 in the time scale of pay as per matrix level 06 for a period of 3 years. During the period of reduction, he will earn increments of pay, and that on expiry, the reduction will not have the effect of postponing his future increments of pay. That is the final order. Only, my lord, I have complained regarding food because I have the stomach problem, my lord. So I demanded, my lord, home cooked food from my quarter, my lord. That's why, my lord, inquiry of sale.
What about your demand for TADA when you fully knew that the communication has not reached? You had,
that, my lord,
you had resorted to a hunger strike.
my lord, because of, my lord, because of food problem and this, my lord, because I have, my lord, complaint, my lord.
Why do you go for hunger strike? You are a part of the discipline force.
My lord, that's my mistake, my lord. So for complaining of food, my lord, the penalty imposed on me is very harsh, my lord. That's my humble sample.
These are not merits. Are you making any grounds on procedural aspect? Can we go into the merits of the allegation? Are you taking any grounds that you are not given a fair hearing, fair chance?
No, my lord. No.
To defend yourself?
No, my lord. I presented myself before the inquiry officer, my lord, answered all questions, my lord.
Yes, on the issue of commensurate punishment, are you relying upon any decision?
No, because, my lord, in the inquiry report, my lord, they have stated that I have complained of food, my lord.
That is what we're asking.
My lord.
On the quantum of the punishment, you said the punishment is harsh vis-a-vis the nature of the allegation. Have you got any decision?
No, my.
How do you assist the court? If you are taking a ground that the penalty imposed is harsh.
Only, my lord, their ground is, my lord, it is discipline force, so I cannot complain, my lord.
What are the decisions that the punishments will be commensurate with the gravity of the offense? Yes, mister.
My only submission is that, Lordship, as there is no challenge to.
Why only submission? Aren't you required to make elaborate submission?
Yes, Lordship, I'll do that, Lordship, with satisfaction to your Lordship. Lordship, firstly, Lordship, they have not challenged the decision-making process, your Lord. Only the penalty that has been challenged, which falls under the minor penalties as per Rule 37 of the CSF rules. And
Okay, let us see the CSF rule. Which rule?
Lordship, I have stated in my affidavit, your Lordship.
No, which rule, which provisions of which rule?
Rule 37 of the CISF rules, 2001, your Lord.
37
37, Lord.
rules,
Rules, Lord.
2001 rules.
Yes, Lord. Lordship, before coming to Rule 37, Lordship, I would like to bring to Rule 34 also, Lordship.
34.
Yes, Lord.
Nature of penalties.
Yes, Lordship, nature of penalties. Kindly see, Lordship, minor penalties. Roman 8. That is the punishment, that is the penalty.
Roman
8, your 8, Lordship.
Okay.
That is the penalty imposed, your Lord.
Not excessive, without cumulative effect. Yes, here
Yes,
there is no
Lordship.
cumulative effect. Because it made it clear that in this time, he would not affect his increments and other benefits.
So because the penalty is a reduction of pay by one state from so and so to so and so, the time scale as per metric so and so for a period of 3 years. During the period of reduction, he will earn increments of pay that on expiry, the reduction will not have the effect of postponing his future increments of
It is
pay.
without any cumulative effect
Yes, Lord.
in consonance with 8.
So the department has rightfully imposed a minor penalty, Lordship, and where they have not exceeded the 3 years period also. Now coming to Rule 37, Your Lordship, the same has been followed by the
37.
department.
37.
37, Rule 37. Procedure for imposing minor penalty. So here, the petitioner has not alleged any violation of this particular rule.
Yes.
And the Lordship may know, Lordship, that the administrative decisions, the witness very law, Lordship. When until and unless there is arbitrary, malafide, or any jurisdictional issue is there, the court has a limited scope of interfering in the quantum of penalty or the administrative decision that has been taken by the department.
He's not even challenging the procedure adopted.
Yes, Lordship.
So
And
those
coming to the
part,
merits,
the only part to be considered is with regard to the whether the penalty imposed is commensurate to the
it does comment,
charges.
Lordship, that has been shown in the Rule 34 of Roman 8, Your Lord. It does commensurate with the minor penalty, Your Lord. And coming to the merits, Lordship, it's a procedure, Lordship. In 15 days, the batch. So 15 days, there has to be rotation. In every 15 days, only the thing is that the petitioner had to go for 15 days, do the duty, and come back to his original post. Only for 15 days.
15 days go where?
To that sensitive zone, Your Lordship.
They are
That Zorazan magazine outpost.
this he was posted as what?
Jorajan, ma'am.
Posted as
A constable, ma'am.
constable.
Only for 15 days, Your Lord. That is also for 15 days. Original post is Lordship CISF Unit Oil Duliazan.
Substantive post, substantive
Yes,
posting.
that is a substantive post which is on regular basis. Every
Substantive posting is at?
Zorazan magazine outpost.
No. You said
Substantive post is at Lordship at a
posting is at
CISF Unit Oil Duliazan, CISF Unit SCCL Singareni.
Duliazan.
That's in Duliazan.
And he needs to go to 15
He
days for-
needs to go to Zorazan magazine outpost.
duty for 15 days.
Only for 15 days. That is a modus operandi that has been going on, Lordship,
Duliazan magazine.
outpost. And that basically it's a hypersensitive zone. And it
Now,
will-
what is the problem here? The problem allegation is of the period when he had when he was serving at Jorazan.
No, Lordship. First, he has to report that Stinganeri, that is CISF unit, that is a major unit, Your Lordship. From that unit, for 15 days, every batch of for persons
Now,
are.
that is what we are asking. That first substantive posting is a Duliazan, the Singaneri. Okay.
Lordship, not exactly substantive post. It's a, first of all, it's a unit.
We are not saying substantive post, it's a substantive posting.
Substantive posting only for 15, substantive posting is that unit.
Yes.
Yes.
Then he goes to Jorazan for discharging duties for 15
For
days.
15 days on a rotation basis.
Okay. What the problem is where? At Jorazan regarding
At
food,
Zorazan.
regarding the food.
Yes, Lordship, because that's a hypersensitive zone. Others are not allowed there. Any communication is not allowed there, Lordship.
And he
it's
needs homemade food to Jorazan.
Yeah, from the main unit, Your Lord. Every batch of the officers, they are cooperating, Lordship. Only he is the one having this problem. And on rotation basis, he has been given liberty also. Preliminary inquiry was done. It is found that he is not only protesting the food, he was also trying to, Lordship, instigate the others to violate
Yes,
the
how-
policy, Lordship.
what, the others are having the same food.
Exactly, Lordship.
How is it possible? And if you're posted at a sensitive area, is it practically possible that every day homemade food would come from your?
And it was a matter of 15 days. And in between, Lordship, we have taken leave also, and we have granted him leave also.
And you're instigating other officers, you're getting complaints, raising complaints regarding TADA. Those complaints have not even reached the headquarters. Going for hunger strike, this gives the wrong signal. You're a disciplined force.
And no major penalty has been taken against him, Lord. That is, I think, the least the department could have done.
And if you start, I will not do it, madam.
That is why you're not given cumulative effect. 3 years, you come back to the same situation. That is not postponing also. Only 3 years. reduction.
I will submit an undertaking, madam. If you start, I will not do it, madam.
To maintain the decorum of the disciplinary course, Lordship, this is necessary.
What is your age?
At now, my lord.
It's 53 at present, Your Lordship, perhaps. At the time of
53,
filing the repetition,
Yes,
it was
53, madam.
51.
Now I am posted at Bongayong now, madam. Bongayong refinery.
Cannot
So
be
there
a
is
fit
no-
case.
He cannot complain for the kudos at this stage.
Cannot be a fit case. It's a minor penalty. That period of 20, it was in 2022, 23, 24, it's going to be over in 25 also. Then you get back everything. Yes, anything else, Mr. Raman?
No, madam.
Okay. Why are you waiting for Mr. Das? Which matter?
One matter, my lord. Item,
Last item.
last item, my lord.
67.
67.
What is it?
That matter, last Friday, this matter came up, my lord, regarding recovery and one increment,
one
they
amount.
were erroneously given one
Okay, okay,
increment.
okay. High Court matter.
High Court matter.
Okay. You had given a suggestion.
Yes,
We can resolve it.
yes, that subject to what my senior says, my lord. Because recovery part, I don't think that will be possible because of Rafiq Masri.
That otherwise also.
But the increment, that 3% advance increment, they were not entitled because list of employees, those the petitioners
Were not there.
categories of
Yes.
post were not there. So that has to be corrected and pay is to be refixed and recovery has to be stopped.
Yes.
In that manner, my lord, it can be disposed of.
Yes.
And he has
Recovery
got
is
one
already
prayer.
stopped, my lord. Recovery is already
I
stopped.
will make that order finally.
An order already as per the interim order, my lord.
And but
recovery
your
is
pay has
already
to be fixed.
Refixed.
Taking into consideration the pay which you received before, prior to grant of the increments.
Yes.
And it was.
Yes, recovery is stopped, my lord. Recovery is.
Whatever you have got, it's just a bonus.
Regarding MSCP, my lord. MSCP, my lord, as per their entitlement, my lord.
Yes,
MSCP
they
is
have
not-
got one prayer for MSCP. My lord, my
MSCP will say, if what, if
Consider.
they are entitled to, they'll consider.
Yes.
That may be at a direct.
Wanted me to prepare one page note
Yes, yes.
for lordship's assistance.
I will pass this judgment right now. Just wait for a while. We'll finish your matter.
Fine.
That Mr. Sharma, because this judgment will take some time in dictating. We'll finish off your matter first. We don't need this. No, Mr. Sharma, we'll dictate your judgment first.
Fine.
Mr. Raman, just wait for a while.
My
We'll
lord.
dictate your order in the court itself. It will হয়ে যাবে, huh?
What matter, my lord? No problem. All the petitioners are grateful staff, my lord,
Yes, yes.
in the establishment of Chief Judicial Magistrate Nalbari.
We'll do it, don't worry. Heard Sri Sharma, learned J. Sharma, learned counsel. For how many petitioners?
Total 11, my lord.
For the petitioners. Also has Sri H.K. Das, learned standing counsel, Guwahati High Court.
2 and 3, my lord.
Who's one? प्रथम पे आर्डर लिखो आर्डर लंडन स्टेट काउंसिल कॉमा श्री एच के दास लंडन स्टैंडिंग काउंसिल हाई कोर्ट एंड श्री आर के तालुकदार लंडन एजी
For my.
for London Standing Council AG Assam. Full stop. This is the hearing column. Hearing column also. Yeah, Chandra. Hearing column also. Okay. The petitioners who are (11) in numbers have joined together in this petition filed under Article 226 of the Constitution of India with a common grievance. It is projected that the petitioners were appointed in various posts
My lord.
of grade 4. Please have your seat.
My
Grade 4
lord.
in the establishment of the Chief Judicial Magistrate, Nalbari. Full stop. The government of Assam had issued a memorandum dated 18/12/2010 for grant of 3% advance increment to certain employees of the state, and by an erroneous presumption that the said notification would also govern. না এটা তো আমি projected case আছে না erroneous presumption না করবে. The petitioners were accordingly granted the benefit of the said OM, said memorandum dated 18/12/2010. Full stop. The petitioners are aggrieved by the action of the state respondents in purporting to withdraw the benefits granted and has also prayed for continuation of the said benefits. Full stop. Sri Sharma, learned counsel for the petitioners, has submitted that the petitioners were entitled to get the benefit of the memorandum dated 18/12/2010 and were accordingly granted such benefits. Full stop. He submits that stoppage of such benefits and the decision to recover the amount which have already been paid would be absolutely harsh. More so when the petitioners are of the grade 4 category. Full stop. The learned counsel has however informed that when this writ petition was moved on 18/7/2018, there was an interim order not to make any recovery from the salaries of the petitioners, and accordingly, the said recovery has been stopped. Full stop. Para. Sri Dhar, the learned State Council has however submitted that though it is not in dispute regarding the issuance of the office memorandum dated 18/12/2010, comma, the said memorandum, however, did not cover the categories of the post held by the petitioner. Full stop. He submits that it was only on an erroneous presumption that benefits were granted to the petitioners. Full stop. However, the said mistake was noticed in the year 2018 when certain communications were made by the Office of the AG Assam, with the Office of the AG Assam, and accordingly, the rectification measure was taken. Full stop. He submits that the petitioners were not entitled at all, not entitled in law to the aforesaid benefits, which were meant for different categories of employees. Full stop. Para. Sri Das, the Learned Standing Council, Guwahati High Court, has submitted, and by endorsing the submissions of the Learned State Council, has submitted that a bare reading of the 11 number of categories in the memorandum dated, in the communication dated 18/12/2010 would clarify that the 11 number of categories of post did not cover the post held by the petitioners. Full stop. He clarifies that the petitioners are in the post of process servers, peons, and drivers, which are not part of the aforesaid communication. Full stop. It is submitted that when the petitioners were not entitled in law to the benefits under such notification, comma, no fault can be attributed to the respondents to make recovery and to stop further payment of and to stop further stop conferment of further benefits, including the payments. Full stop. Sri Das, the Learned Standing Council, has, however, fairly submitted that so far as the recovery order is concerned, comma, apart from the order of stay by this court, comma, the Honorable Supreme Court, in a catena of decisions, including the one of Rafiq Masi, Whitewasher versus Union of India.
State of Punjab.
State of
versus
Punjab.
Rafiq Masi.
State of Punjab versus Union of Rafiq Masi, reported in
2015, 4 SCC 334.
2015, 4 SCC 334, has submitted that this court may pass appropriate orders on the recovery aspect. Full stop. He, however, submits that once the error has been detected, comma, further grant of benefit would not be in accordance with law. Full stop. Sri Talukdar, the Learned Counsel for the AG Assam, endorses the submissions of his colleagues appearing for the respondents. Mr. Das, you are also appearing? No. The rival submissions have been duly considered. The controversy revolves around the communication dated 18/12/2010, on the basis of which certain benefits, namely 3% of advance increment, was granted to the petitioners. Full stop. A bare perusal of the said communication would, however, reveal that the post to which such benefits would be granted were identified. Full stop. The said identification extends to 11 numbers of posts with a further stipulation that the benefit is also to be extended to other common category posts in the ministerial cadres other than those to whom higher pay scale is recommended by the Commission. Full stop. The identification of the post and the further stipulation makes it amply clear that such benefits were meant only for ministerial cadres, whereas the post in which the petitioners are serving are of grade 4. Full stop. It becomes apparent that the benefit of the notification were given to the petitioners by an erroneous construction of the said communication dated 18/12/2010, which, however, came to the notice in the year 2018, and accordingly, the impugned action was taken. Full stop. The impugned action per se cannot be held to be legally infirm or cannot be held to be suffering from any legal infirmity. Full stop. At the same time, comma, this court cannot be oblivious of the fact that the petitioners belong to the lowest grade, namely grade 4 of the cadre. Full stop. This court is also guided by the principles laid down by the Honorable Supreme Court in a catena of decisions in this aspect, including the case of Rafiq Mashi Supra, wherein for the lower grade employees, recovery has been discouraged. Full stop. Para. In view of the aforesaid facts and circumstances, this court is of the considered opinion that the interest of justice would be served and the equities would be balanced by directing that while the benefit of the notification dated 18/12/2010 would not be granted to the petitioners as they are not entitled, such decision would be taken prospectively from the date on which the error in granting them the benefit came to be noted. Full stop. It is however made clear that the recovery from the salaries of the petitioner is not to be made. Full stop. The petitioners are, however, required to be placed in their proper fitment by calculating, but by fitment, by reckoning them fitment from the date when such erroneous benefits were given to them. Which date?
Perhaps, their pay has to be refixed on
Refixed.
that particular date.
It is-
That is, they were given from 1/4/2003. Otherwise, their pension after retirement age will again raise objection. Again, there will be problem.
1/4/2003. Full stop.
Excluding
The-
that one increment.
The pay of the petitioners are accordingly directed to be refixed and intimated to the AG Assam. Especially for, are you still in service? You are in service.
They're still in service.
Still
No,
in service.
that is the apprehension I am just thinking.
No,
But
no,
their pay is to be refixed on 1/4/2003 because at that point of
Yes,
time.
1/4, we have, that is why.
Yes.
Because this gave effect from 1/4/2003.
1/4/2003. Yes.
Oh.
So one
The-
line lordship has written that has to be given prospective effect. Then from the date of detection.
No,
Detection was
not
in
prospective.
2000.
Detection.
Detection in 2018.
18 onwards, they will not get.
But they were
You-
not entitled from on that particular date, 1/4/2003. It was erroneously given. So that one increment has to be excluded from 1/4/2003. Because that pay has to be refixed without that increment on 1/4/2003. No recovery.
Without
But
recovery.
pay is to be refixed, excluding that one increment from 1/4/2003, or the error will remain.
Go on. It is clarified that since our upward document change immediately to give from effect from 1/4/2003, it is clarified that the refixation of the pay has to be done by excluding one increment from the date of effect of the notification dated 18/12/2010, which was from 1/4/2003. And in the up where we have referred the notification, we'll write about this 1/4/2003.
Yes.
My lord, my second prayer may be put, a direction may be issued, my lord.
MACP will also be
MACP.
direct to
As per
consider
entitlement.
as per their
Uh,
entitlement.
At this stage, Sri Sharma, the learned counsel for the petitioner, has prayed for consideration of the case of the petitioners for grant of MACPs. Full stop. It is needless to state that grants of MACPs have to be done if the petitioners are otherwise found eligible
Yes.
in terms of the existing norms.
My lord, obliged.
Deeply obliged.
We'll do one thing, since it's a consent kind of an order, before we sign, we'll hand over a copy tomorrow.
Fine, man.
There should not be any difficulty.
Fine, man. Fine, man. Highly.
IA for?
Oh, I for.
I am, my lord, I am
It can be disposed of.
In view of this,
Obliged.
the imposition of the penalty of reduction of pay by one stage এরপর করে দেবো, হ্যাঁ? Wide and order dated 14/2/2022 upon the petitioner, which is also affirmed by the appellate authority, which had rejected the appeal on 4/7/2022, are the subject matters of challenge in this petition filed under Article 226 of the Constitution of India. Full stop. The challenge is not on the procedure adopted in the disciplinary proceeding, but mainly on the aspect of the penalty being termed as disproportionate to the gravity of the offense. Para, the facts projected in the petition is that the petitioner has been serving as, what is HC? Head constable. Head constable. Head constable, GD.
General duty.
GD of the Central Industrial Security Force within bracket CISF, and at that time was posted at the CISF unit Oil India Limited, Duliazan, industrial sector. Full stop. The personnel of the CISF were required to discharge their duties for 15 days.
2 weeks, Your Lord.
For 2 weeks on rotation basis at a sensitive location at under Zorazan outpost.
Magazine outpost.
At the magazine unit. What do you call magazine?
Magazine outpost of industrial sector.
Magazine outpost of the industrial sector. Full stop. It is the case of the petitioner that during such deputation, the food served in the mess was of inferior quality, and the petitioners had lot of difficulties. Full stop. He had therefore requested for homemade food. Full stop. It also appears that the petitioner had raised issues of grant of TA and DA, which according to him were not given. Full stop. It is the case of the petitioner that because of raising of such objections, a disciplinary proceeding was initiated against him, which had culminated in the aforesaid order of penalty. Report to hereinafter penalty boli korim, no? Order of penalty. Full stop. The appellate penalty. As indicated above, the appeal against the said order was also dismissed on 4/7/2022. Full stop. I have heard Sri S. Raman, learned counsel for the petitioner. I have also heard Sri D.J. Das, learned CGC, who has submitted that affidavit in opposition has also been filed on 21/10/2022. Full stop, para. Sri Raman, the learned counsel for the petitioner, has submitted that initially the petitioner had filed WPC 2183 of 2022 against the impugned order of penalty dated 14/2/2022. Full stop. However, the said writ petition was withdrawn with a liberty to file an appeal before the authorities, which was accordingly done. Full stop. However, the appellate authority, by order dated 4/7/2022, had rejected the appeal, and thereafter the present writ petition has been instituted. Full stop. The primary contention of the learned counsel for the petitioner is that the allegations against the petitioner were not serious in nature. Full stop. It is submitted that the petitioner had raised a genuine issue of grant of proper food in the mess and the problems suffered by him in absence of proper food. Full stop. It is submitted that by raising of such grievance, no allegations can be framed against the petitioner. Full stop. It is also submitted that the penalty imposed is a serious penalty and is not proportionate to the gravity of the charges. Full stop. It is submitted that the reduction of pay for one stage has been done for 3 years, and the said penalty, even if to be imposed, can be reduced by certain number of years. Full stop. The learned counsel has submitted that rejoinder affidavit has been filed on 27/4/2023. Full stop. By drawing the per contra, the Sri Das, the learned CGC, has strenuously opposed the writ petition. Full stop. It is submitted that the CISF as such is a disciplined force, and it is the foremost duty of every personnel of the CISF to maintain discipline whilst discharging their duties. Full stop. He submits that the deputation of the petitioner to the magazine outpost was not confined to the petitioner alone, but was in a large group, and there was no complaints from any other officers, from any other personnel on the aspect of food. Full stop. While denying that there was any inferior food supplied to the personnel, it is submitted that it is in the interest of the establishment that proper food is served on the personnel as they are engaged in hazardous duties. Full stop. The CGC has further submitted that the petitioner had not only raised complaints on baseless grounds, but had also instigated other personnel, not only other personnel, full stop. Such instigation was not only confined to the aspect of food, but also to the aspect of grant of TA and DA, which were non-existing. Full stop. Para. By drawing the attention of the Central Industrial Security Force Act 1968 and the rules framed thereunder, namely the Central Industrial Security Force Rules 2001, the learned CGC has referred to Rule 34, which deals with minor penalties. Full stop.
Deals with both major and minor.
Which deals with penalties. Which deals with nature of penalties. Full stop. It is submitted that under 34 within bracket Roman 8, where the present penalty has been prescribed, comes under minor penalties. Full stop. The learned council has also referred to Rule 37, which lays down the procedure for imposition of minor penalties and submits that the procedure has been duly followed. Full stop. He accordingly submits that no interference is called for in the present case and the writ petition be dismissed. Full stop. The rival submissions have been duly considered and the materials placed before this court have been carefully perused. Full stop. Para. The challenge, as indicated above, is only on the aspect of the severity of the penalty imposed vis-a-vis the nature of the allegations. Full stop. No procedural impropriety or infirmity has been alleged as submitted by the learned counsel for the petitioner. Full stop. To examine the said aspect, this court has looked into the nature of the charge. Full stop. The charge is of causing unrest and indiscipline in the working of the establishment by raising baseless allegations on the aspect of the food which were served in the magazine, served to the personnel deputed in the magazine outpost. Full stop. As would appear, such deputation is on a sensitive location and has been done on rotation basis for a period of 15 days. And the same involves a number of personnel. Full stop. There is nothing on record that there was allegation of inferior food being served by any other personnel. Full stop. The protest raised by the petitioner on the issue of grant of TA and DA also does not appear to be based on any substance. Full stop. The materials on record would show that the petitioner had resorted to a hunger strike on the aforesaid issue, which would undoubtedly appear to be a kind of instigation to the other personnel. Full stop. The personnel, as observed above, belong to a strict discipline force wherein the personnel are entrusted with serious duties of guarding industrial locations, amongst others, and are guarding important establishment. Full stop. This court has also taken note of the rules governing the field. Full stop. The rules of 2001, more particularly, Rule 34, within bracket 8, as noted above, would show that the penalty involved is a minor penalty. Full stop. The procedure for imposing minor penalties is laid down in Rule 37 and as recorded above, the challenge is not structured on any procedural impropriety. Full stop. This court is of the considered opinion that the penalty, which is a part of the minor penalty, cannot be said to be grossly disproportionate or severe vis-a-vis the nature of allegations against the petitioner. Full stop. The penalty order makes it clear that in the period of reduction, the petitioner will earn increment of pay, and after expiry of the reduction, there will be no effect of postponing his future increments of pay. Full stop. In the considered opinion of this court, the penalty imposed appears to be justified, more so when the petitioner is employed with a discipline force. Full stop. In view of the above, this court does not find any grounds to interfere with the impugned order, and accordingly, the writ petition is dismissed.